Good morning, everyone. Good morning, Charm TV. The October 10th, 2024 proceedings of the Board of Liquor License Commissioners for Baltimore City will now begin. Please take this opportunity to turn off or mute all of your electronic devices. The board is now in session. Note, Chairman Matriciani is excused from today's hearing, so in his absence, Commissioner Templeton will serve as chair. Case 1, DeVry Summerfield, Hazel Street, LLC, trading as Sooners Tavern, 1600 Hazel Street, Class BD7, beer, wine, and liquor license. Request to reopen under the provisions of the Alcoholic Beverages and Cannabis Articles, Section 12-2203, wherein a licensed premises has been closed for at least 3 consecutive months. Please come forward.
Good morning.
Good morning. State your name for the record.
Deborah Summerfield.
Okay. Dante Summers,
Press the button that has the,
the little there. Okay. What's your reason for your request to reopen?
Well, it's been closed for a while. We just wanted to reopen it. We was trying to get away from some of the stuff that was going on in the neighborhood. So by being a shooting in that area, we just tried to close it down for a minute to get some of the people away from that area to not want to hang in that area. So by us closing, we gave it enough time for it to kind of move away from that where we were, because it became a little dangerous for us in that area. So we kind of closed it to let it be.
And you guys are ready to reopen now?
Yeah.
Okay. Any questions from the commissioners?
Are you working with, are the police working with you?
Police always been there, but you know, we got the cameras and everything hooked up, so in case they ever need any footage, that's where they came to get everything.
Right.
It was all right, but we just felt as though it was just a little bit dangerous in that area.
No, I'm just saying, because I used to represent that area. I know how it is sometimes.
Yeah.
Okay. You have any questions?
No.
And you sent your letter on, I think, August 30th. Based on your August 30th email to the Liquor Board and your testimony given today, I vote to approve your request to reopen this Class BD7 beer, wine, and liquor license.
Yes, based on material and testimony provided today, I also vote to approve the request to reopen.
Based on the application file testimony given by you here today, I also approve the request to reopen the establishment at 1600 Hazel Street.
Good luck to you guys.
Good luck.
Thank you.
Mr. Page?
Mr. Summerfield, no exhibits for the record.
All right. Good luck to
Thank you.
Okay.
Tyler J. Stanek, secured creditor, no trade name, 3500 O'Donnell Street, Class BD7, beer, wine, and liquor license. Request for hardship extension under the provisions of the Alcoholic Beverages and Cannabis Articles, Section 12-2202. Please come forward.
Good morning, Commissioners. I'm Andrew B. Saller. I represent Mr. Stanek, who's standing to my right.
Good morning. So you guys are ready. You need a hardship extension?
Yes, Commissioners. Mr. Shawls actually is representing a prospective tenant. I owe him a lease. They're making some tenant improvements to the facilities, particularly the kitchen areas, and all of this should be done in short order, and I believe Mr. Shawls will be representing the transferee in the near future.
We should have an application within 2 to 3 weeks.
Okay. Can you identify yourself if you're going to say something? Just for the record.
Frank Shawless, I represent the prospective purchase.
Okay. All right. I have no other questions. Do you have any questions?
No question.
Okay. Based on your September 12th letter and your proffer made today, I vote to approve this 180-day hardship extension for this Class BD7 beer, wine, and liquor license.
Yes, based on materials and testimony and the letter from the attorney, I also vote to approve the request for hardship extension of 180 days.
Based on the application file, letter dated September 12, 2024 from Mr. Andrew Saller, and testimony given, I approve the request for a 180-day hardship extension.
Thank you. Good luck, Mr. Page.
Thank you.
No exhibits.
Kumar Dangle and Govinda Roca, 36th Street, LLC, trading as Hamden Spice Bar, 1125 through 31, West 36th Street. Class BD7 beer, wine, and liquor license request for transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
Thank you. Good morning. Stephen W. Fogelman on behalf of the applicants. Good morning.
Good morning.
Chair Pro Tem, Commissioners. Always a pleasure. This one was approved by the board for transfer on March 7th. September 3rd was the 180-day deadline, so we filed to ask for an extension for 90 days after September 3rd. Renovations were taking place, quite frankly, that significant renovations that I wasn't aware of, and if I was, I probably would have said, you need to probably do this before you file. But it's in the process of being ready for final inspections and completion of the transfer. Thank you.
Okay, thank you, Mr. Fogelman. Any questions?
No questions.
None.
Okay, based on your August 19th letter, your proffer made today, I vote to approve this request for transfer hardship extension for 90 days for this Class BD7 beer, wine, and liquor license.
Yes, based on materials, a letter from the attorney, and also the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter dated August 19th, 2024, from Mr. Fogelman, and also proffer given by him here today, I approve the request for a 90-day transfer hardship extension.
Executive Secretary? Mr. Page?
No exhibits, Mr. Chairman.
All right, thank you very much.
Thank you.
Sapana Danpali and Sudeep Raj Upredi, 413 West Baltimore Street LLC, trading as Baltimore Spice Restaurant and Bar, 413 West Baltimore Street, Class BD7, beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
Thank you. Stephen W. Fogel on behalf of the applicants. The board approved the transfer of this license on March 21st. They are still wrapped up in inspections for the transfer completion and the use and occupancy. So their 180 days expired on September 18th, and we've asked for 90 days from September 18th. Thank you.
Okay, any questions from the commissioners?
No questions.
None.
Okay, based on your August 19th letter, the proffer made today before us, I vote to approve this request for a transfer hardship extension of this Class BD7 beer, wine, and liquor license.
Yes, based on materials, letter from the attorney, and also the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter dated August 19th, 2024, and proffer given by Mr. Fogelman, I approve the request for a 90-day transfer hardship extension.
Thank you.
Thank you.
Mr. Page?
No exhibits, Mr. Chairman.
Lucas Ramirez and Pete Coronius, HTMD LLC, trading as Broadway Diner, 6501 Eastern Avenue, Class B, beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
Mr. Priebus?
Good morning, Mr. Acting Chairman, members of the board. Peter Priebus on behalf of the applicants. This is a 90-day hardship request. The one problem we had is when the sales tax license was issued, it had the trade name only and not the LLC name, and we just need to fix that and figure out who we can talk to get that done. Once that happens, everything else will fall into place, and we'd be able to transfer.
Okay, no questions. Any questions?
No questions.
Okay, based on your August 6th letter, your proffer made today, I vote to approve this request for a transfer hardship for 90 days of this Class B beer, wine, and liquor license.
Yes, based on materials, letter from the attorney, and the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter from Mr. Priebus dated August 6, 2024, and proffer given by him, I approve the request for a 90-day 90-day transfer hardship extension.
Okay, Mr. Page?
Thank you.
No exhibits, Mr. Chairman.
Okay, thank you, Mr.
Kabita D. Mahat, Gorica LLC, trading as Eddie's of Mount Vernon, Southwest Eager Street, Class A, beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
Mr. Fogelman?
Yes, thank you. Stephen W. Fogel on behalf of the applicant. Eddie's of Mount Vernon grocery store that also has a liquor license. They applied for a grant from the state. The state trying to encourage grocery stores and communities. Apparently, I guess it was first time getting a grant approved because the money takes longer than one might think it would, first timer. Nevertheless, they've had construction delays, a change of contractor, and then the delay in getting the approval and reimbursement from the state under this grant. This was approved on March 21st. Transfer needed to be done by September 18th, so we're asking for 90 days from that date.
Okay.
Thank you.
Thank you. Any questions from
No.
Commissioners?
No questions.
All right. Based on your September 4th letter, your proffer made today, I vote to approve this request for a transfer hardship extension for 90 days of this Class A beer, wine, and liquor license.
Yes, based on materials, letter from the attorney, and also the testimony, I also vote to approve the request for a transfer hardship extension of 90 days.
Based on the application file, a letter dated September 4th, 2024 from Mr. Fogelman and proffered by him also, I approve the request for a 90-day transfer hardship extension.
All right. Mr. Page?
No exhibits, Mr. Chairman.
All right.
Thank you all.
Appreciate it.
Layla Alahida Valdechek, 4537 Hartford Road, Wilson's LLC, trading as Wilson's Tavern, 4537 Hartford Road. Class BD7 beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705. Please come forward.
Mr. Kadensky?
For the record, Melvin J. Kadensky, representing the applicants and licensees. Pursuant to my letter, we've had some discussions with the health department and the building. I think they're pretty close to getting that cleared up, but they'll need a few more days or maybe a week or two. It just seems that it's hard getting the city to respond. When you send them something, it takes a week for them to get back to you. So I think that should be okay in about, if you give the hardship extension.
Okay. Any questions, Commissioners?
No questions.
Based on your proffer made today and your September 13th letter, I vote to approve this request for a 90-day hardship extension of this Class BD7 beer, wine, and liquor license.
Yes, based on materials, letter from the attorney, and also the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter dated September 13th, 2024 from Mr. Kadensky, and the proffer given by him, I also approve a 90-day transfer hardship extension.
All right. Mr. Page?
No exhibits for the record.
Thank you. You have the next one, too.
Yeah, I have two more.
Regina Kaur and George Martin Mooney, Kowalty LLC, trading as Hollabird Bar and Liquors, 6701 Hollabird Avenue, Class BD7, beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B.
Once again, for the record, Melvin J. Kadensky, 320 North Charles Street, representing the applicants. This is a case where there was a mix-up in the use of the occupancy certificate. For some reason, the inspectors kept going to the second floor. We had to tell them that there was nothing to do with the second floor. The license only had to do with the first floor. They're doing their re-inspections. It should be finished within the next 30 days or so.
Okay. Any questions, Commissioners?
No.
No questions.
Based on your proffer today and your September 13th letter that you submitted, I vote to approve this request for a transfer hardship extension for 90 days for this Class BD7 beer, wine, and liquor license.
Yes, based on materials, the letter from the attorney, testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter dated September 13th, 2024 from Mr. Kadensky, and proffer also given by Mr. Kadensky, I approve the request for a 90-day transfer hardship extension.
All right. Mr. Page?
No exhibits, Mr. Chairman.
Thank you.
Jaswinder Singh and Richard Everett Hackett, Jerry Inc., trading as Jerry's Belvedere Tavern, 5928 York Road. Class BD7 beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B.
Once again, for the record, Melvin J. Kadensky, 320 North Charles Street, representing the applicants in this case. We've been having fits with the Comptroller's Office. I don't know whether they lost their records from the cellar or what, but I think The seller is Mr. Davis, been with the controller. We may have this cleared up next 30, 45 days.
Any questions, Commissioners?
No questions.
No questions? Okay. Based on your proffer made today, your letter of September 13th, I vote to approve this 90-day request for a transfer hardship extension of this Class BD7 beer, wine, and liquor license.
Based on materials, letter from the attorney, the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file and letter dated September 13, 2024 from Mr. Kudinski, I think, and proffer given by Mr. Kudinski, I also approve the 90-day transfer hardship extension.
Mr. Page?
No exhibits for the record, Mr. Chairman.
All right. Thank you very much.
Thank you.
Iyab Pasaya and G'day Kasey Gibruet, I apologize. EMA Liquors LLC, trading as Green Tree Liquors, 1400 West Baltimore Street, Class A, beer, wine, and liquor license. Request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article Section 12-1705B.
Good morning, Mr. Acting Chairman, members of the board. Peter Previs on behalf of the applicants. This, again, is a 90-day transfer hardship request. The issue holding this one up was when you file your liquor license transfer application, you have to file a use and occupancy permit. That's done before the property sold. Then the use and occupancy permit gets issued, and then if you don't catch it before it gets issued, they can't amend it, and you have to file for a whole new use and occupancy permit. So we had health is approved, fire is coming out, and we'll get building and plumbing and electrical, and we should be done.
Okay. Any questions?
No questions.
None.
All right, based on your September 13th letter, proffer made today, before us, I vote to approve this 90-day request for a transfer hardship extension of this Class A beer, wine, and liquor license.
Based on materials, letter from the attorney, and the testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on the application file, letter dated September 13, 2024 from Mr. Previs, and also his proffer, I also approve the 90-day transfer hardship extension.
Thank you, Mr. Page.
No exhibits, Mr. Chairman.
Thank you very
Thank
much.
you very much.
Moving into violations. Jamie L. Balbuena Bravo and Alejo J. Martinez, El Oasis Restaurant E Discotheque, Inc., trading as El Oasis Restaurant E Discotheque, 3919 through 21 Eastern Avenue. Class BD7, beer, wine, and liquor license. Violation of Liquor Board Rule 3.12, general welfare, on May 25th, 2024. Loud music. Please come forward.
The commission, please. Frank Solis, representing the applicant for the licensees.
1 second. Go ahead, you can swear them in. Anybody that's going to testify, please raise your right hand.
If I can beg your pardon, I have one more witness outside. Can I get them?
Yeah, you can have them come in now.
Okay.
You trying to sequester somebody?
Where are they, downstairs?
Are they going to testify now? We can swear them in once they come up, so let's move forward.
Okay. You can raise your right hand.
She's doing
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Okay. Who was?
I will be.
Yeah, go ahead. Is this going to, first of all, I want to know, is this going to be an admission or is this going to be contested?
Contested.
It's going to be contested. Okay. Go ahead.
sorry.
Thank you.
Mr. Shaw.
Inspector Jordan, Baltimore City Liquor Board. I responded to a 311 complaint on May 25th, 2024, approximately 11:45 p.m. The allegations were of loud music, and I approached the location via Fleet Street, approximately 400 feet away from the location, so it would be the rear street. The location is on Eastern Avenue. I parked my car on Fleet Street, and I could hear the music coming from the location. I parked in the front to approach the location by foot, and when I parked there, the music and the bass was so loud that the windows on my car were vibrating. That's how loud it was. I spoke to Mr. Alejo, and I let him know that we received a 311 complaint for loud music, and I reminded him that he had already gotten a warning for the loud music on 4/27/24 in April.
Objection.
What's the reason for the objection? You objected, what's the reason for your objection?
It's not relevant to what happened the night he was charged.
Okay, go ahead and continue.
After I just let him know that he was getting a violation, and that was the end of my visit.
Okay, how far away did you park?
When I could hear the music, when I parked on Eastern Avenue, was right across the street. But I parked behind the location 400 feet away the first time. I assessed the noise.
Okay, any questions? Go ahead. No.
Yes.
Counsel.
Now, you said the music was loud. Do you know what the regulations call for as far as loud music?
If I could hear it and I'm a block away, it's too loud because there's homes behind the location. There's townhomes in the rear of the location.
And what regulation of the city was violated?
We don't go by the city regulations.
The regulation is here for this violation of Rule 3.12, general welfare, so.
Well, I understand, Your Honor, but I wanted to ask her the question about it. Just how did you determine that the noise was so loud that it exceeded the requirements of the law or violated the regulation?
Just based on my judgment and the fact that we got a complaint, a 301 complaint, a neighbor was complaining, and when I assessed it, it was loud.
Whenever there's a complaint, you have to go out and check?
Yes.
And did you receive any training in sound, volume, or what would affect the welfare of the people as far as what volume?
We don't use any type of reading, if that's what you're asking. We just go based on our hearing. And if it's disturbing somebody because it's loud, and then when I go out and it's loud, it confirms that it is too loud.
So you don't use any instrument to measure the sound level?
We are not issued or trained with any instrument.
So no training, no instrument?
No, that would be
based on-
I believe the health department
It's
does that.
loud, so I think
Yes.
it's loud. Different people have different levels of hearing, would you agree?
Oh, sure.
Because I can't hear it. Okay, thank you very much.
You're welcome.
Any other testimony? Okay. Go ahead.
State your name, I'm sorry.
Andy Perez.
All right, are your witnesses going to testify now?
I'm sorry.
Are your witnesses going to testify?
Yes, but first I make a motion to dismiss.
Oh, deny.
There's nothing, well, that was.
Well, go ahead and give your argument.
Just a slight argument. In order to commit something, in order to take somebody's livelihood, in order to deprive them of property, you've got to show that they violated the law. Now, the law hasn't even been introduced here, and there's no evidence to back up what the regulations require for it. There's a state and there's a city regulation regarding sound. It requires that you have a decimeter or decibel meter, I don't know which one it's called, and that the sound levels, in order to affect the welfare of the general public, has to exceed that. And that was the very law that you cited, the regulations you cited. I have heard no evidence whatsoever that any such regulation was exceeded. And she said that she's not trained and she didn't have any instrumentation to show that there was, just saying it's loud, but what is loud to me is not loud to you maybe, or vice versa in my case.
Okay.
So on that basis, I don't think they've proven any charges. They haven't proved any kind of violation.
At this point, I'm going to deny your motion. She did state that it was loud. She did state that it was a number of, I guess, blocks away when she pulled up. Also, there are multiple statutes, which I'm not going to go into. There's the health department that deals with decibels, but in order to be violated under the general welfare, it doesn't have to be a decimal reading for that. So at this time, there does not have to be a decibel reading under this general welfare rule for it to be violated. So at this time, I'm going to deny your motion.
If I may bring up one more point. As I said, there's a state law.
Well, you can bring it up after your, unless you don't want testimony from your witnesses.
They're not going to testify.
Okay, go ahead.
Except the mitigation, if my motion is denied.
Okay, so go ahead with your evidence.
Am I to prove the state's case?
No, you stated that you had something else you wanted to
I
show.
have mitigation.
Oh, just in mitigation.
Yeah, just mitigation.
Okay. So initially, you made a motion after the testimony, and so I thought you were going to put your case on. You're saying you're not going to put a case on now? Okay.
I'm renewing the motion.
You're renewing your motion. Okay. Based on the testimony given today, any questions from the commissioner?
No, I just want to say to the counselor that she is trained and that they've had 9 prior violations, 2 suspensions, and they've been hit with some heavy fines. So that's it, Mr. Chair.
Okay.
Just for the inspector, you did say that a complaint was received from the public,
Yes,
and that's what initiated your inspection?
yes.
All right, thank you.
Okay. Based on the, let me get the date right, 1 second. Based on the violation report that was submitted by our office, based on the testimony that was given by the inspector, and based on the proffer made by counsel, without any testimony from the clients, I do see that there was a violation of Rule 3.12, General Welfare, in this matter. Before, I guess, I make a ruling, I will let you have your mitigation before we rule on that, but let's get the rulings from the rest of the commissioners before we do that.
I'm good.
Based on the May 25, 2024 inspection, lost my point here. Excuse me for a second. Based on the testimony given, I find for a violation. You don't want us to do the violation of guilt or not yet?
At this time, we want to, I'm making a ruling on whether or not I find there's a violation, but in mitigation, I was going to allow you to do your mitigation before we state what the violation fine would be and the time limit if we do give a fine.
All right.
Okay.
Based on the testimony given, I'm delaying my vote whether to be guilty or not guilty. But the general welfare on May 25, 2024, loud noise. The music was loud on May 25, 2024. Now I'll delay everything else because I can't complete my thought until I can say guilty or not guilty. Back to you, sir.
So what we're asking is for you to make your decision on whether or not there's a violation of 3.12 3.12 at this time, and we'll delay our decision until we hear mitigation. So,
Oh, okay. Yes, based on materials and testimony provided today, I agree with the violation of Rule 3.12, general welfare.
Okay, go ahead with mitigation.
Let me go first. Based on,
Let's hear mitigation first before.
I think he just gave you this.
Okay. Here's the mitigation. Since that time, I have pictures here which I'll introduce. They have padded the whole back. Do you have the insulation? With this insulation to deaden the sound, including the back door. They've covered the entire wall, they've covered the door. They also, do you have the devices? Okay, but in mitigation, I have to call one witness, if I may.
Go ahead.
Come on.
I don't think.
He isn't sworn in.
Let him be sworn in, yeah.
Can you raise your right hand? And I have to ask, are you going to be interpreting what she's saying, or are you speaking for yourself? You're going to be, you're going to
Yeah.
interpret? Okay, then I'm going to need to swear you also, and I'm going to need to swear you first as the interpreter. Do you swear or affirm to translate or interpret the spoken words of the witness to the best of your ability?
Yes.
Thank you. And now I'll swear you in. Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please.
Can you stand over here?
Yeah, you get up there.
Alejandro Bonilla, A-L-E-J-A-N-D-R-O. Bonilla, B-O-N-I-L-L-A.
Now, you're the manager of the area, is that correct?
Yes,
Yes?
yes,
Okay. And after this incident of May, you took certain measures to deaden the sound, is that correct?
Porque sí dice de que después de todo lo que instalaste y así, tú tomaste precaución en revisar todo lo que suena adentro y afuera.
sí, correcto.
Yes.
And you installed this padding on the rear of the building, rear of the interior of the building, and that covered the door too?
Y que si pusiste eso alrededor y enfrente de la puerta también.
Sí, correcto.
Yes.
Now, you also installed a sound automatic cutoff at a certain decibel level in the sound system, is that correct?
Yes,
And this sound system controls all of the musical amplification, is that correct?
I control the mixer, yes.
And that, as soon as it reaches a certain decibel level, it cuts the music off, is that correct?
It is.
Now, also, you have a portable decimeter where you check the outside.
We have one we can walk and go outside and around.
And since that incident, have you been checking the outside?
I check every day.
Has it ever exceeded the decibel level that I told you was within the article of the law, the regulation from the state and the health department?
Que si se ha pasado el número que hay dicho en décimos.
No.
No.
That's all.
And Mr. Chair, I'm sorry if I could ask, can the interpreters, can you state and spell your name?
Janet Salazar Martinez.
Okay. Any other questions? Any questions?
Yes, was that installation installed before the last violation? or
No, after.
After?
Yeah, it's after everything was installed after, because we're trying to mitigate the whole thing. And that's my argument. They spent thousands of dollars trying to mitigate that sound, and this is what we've got. I know they will not let it happen again. They're aware of the seriousness of it. They don't want to come back to see anymore. They've already spent a fortune to take care of this matter. They are now policing it with the proper equipment. They are not going to violate the regulation anymore. That's all that we can do. This is an establishment that I've known. I'm 81 years old, and it's been there since I was 10, at least. It was a country western place known as the Bills. I lived by Eastern Avenue. This has always been the same. Nothing's changed, except maybe the people that live around there calling in complaints.
Go ahead.
I have a question. The grade of that material that you have in your hand, do you have anything in writing to show the spec? I mean, any documentation stating what it's supposed to do? I mean, anybody can put a wall covering up. That doesn't mean that it's going to stop the doors from coming out.
I agree with you wholeheartedly, but this is the best soundproofing stuff that Home Depot says does the
But
job.
you need to have something in writing to support what you're saying.
Well, Mr. Commissioner Jones, I agree with you. But here, because it's loud and somebody's here, they're saying that they're violating the regulation, and then Your Honor has just read me the regulation. Well, they don't know the regulation.
They know it because they charge you. It's general welfare.
Well, what
We're
is the
not
general
arguing
welfare?
over-
It doesn't, they violate my general welfare when I have to walk out and go over city sidewalks that have holes in them.
Well,
'cause I
Counsel,
can barely
we
walk.
made a decision on whether or not there was a violation. This is mitigation.
Right, I'm
So
sorry.
let's not
I didn't mean to
relitigate
argue with
the decision that's already been made. Inspectors, have you been back since this installation has been put in?
I myself have not been back. He did mention looking into some materials, and I informed him that there's professionals that just do that and know exactly what materials to use and where to put the material. So I'm not sure if he consulted with a professional, but I haven't been back.
Okay.
I have been back within the last month at least twice for loud music complaint. I found those complaints unfounded.
Okay.
Right.
And that was after the installation has been put in?
I'm not sure when this installation was installed, but I was there Tuesday of last week.
Okay, that's great news then. Okay, I'm ready. So as to our violation of Rule 3.12, as I said before, I do find that there was a violation on May 25th, 2024. Due to your mitigation, showing that extensive measures have been made despite the multiple violations that we've seen on here, I'm happy to hear that steps have been made to mute or to make sure that the sound does not get to the neighboring homes and area. I will give a fine of $2,000. I will give 30 days to pay.
Yes, based on material testimony provided today, I agree with the chair's findings, a violation of 3.12 general welfare and with a $2,000 fine.
Based on the testimony given, I find for a violation of Rule 3.12, general welfare. I also attach a $2,000 fine to that, and of course with everybody in alignment with everybody else here.
Okay.
Yes, I just want to emphasize to the council to talk to your clients that having a liquor license is a privilege, okay? Because I'm looking at the 9 prior violations and 2 suspensions, I don't think they comprehend that.
Yeah, and another thing is that normally we escalate every time there's a violation. As you can see, the last violation, we find more than this. And I went down from the last violation, which is it's not a normal thing. And it's because we see that steps are being made to make this an establishment that doesn't harm the community, but it should be a help to that community on Eastern Avenue. I pass that by it all the time, yeah.
Thank you very
All
much.
right, good luck, you guys.
Mr. Charles.
And Mr. Page?
Exhibits for the record, please. Exhibit number 1, violation report. Exhibit number 2, serve summary, summons. Exhibit number 3, service of summons. Exhibit number 4, installation of soundproofing. Thank you, Mr. Chairman.
Thank you. All right, let's go on to the next one. We have a full docket today.
Yep. Kivia Beard Moore and Richard L. Nelson, Richie's Entertainment LLC, trading as Richie's Lounge, 1600 West Baltimore Street, Class BD7 beer, wine, and liquor license. Violation of Liquor Board Rule 3.082, sanitation and safety, on July 2nd, 2024, for excessive amounts of uncontained and improperly stored trash outside the establishment, and violation of Liquor Board Rule 3.082, sanitation and safety, on August 12th, 2024, for the same thing, excessive amounts of uncontained and improperly stored trash outside the establishment. Please come forward.
Can you please state your name for the record?
Hi, good morning, Richard Nelson.
Okay.
Swear in, Mr. Chair.
Yes, go ahead.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Nelson, is this going to be an admission to the trash?
Yes.
Okay. All right.
Good morning. For the record, Chief Chris Amalis, Baltimore City Liquor Board. On July 2nd at approximately 10 o'clock, I received an anonymous call in the office about large amounts of trash outside of 1600 West Baltimore Street. At that time, I called Agent Clark, and he responded to the location where he found large amounts of trash, which he has provided pictures and wrote the violation.
Okay.
On August 12th, I responded to the establishment for a complaint of excessive amount of trash. Upon my arrival, I observed several overfilled trash cans and boxes spilling onto the ground near the side door of the establishment. The establishment was closed. I was not able to inform Mr. Nelson of the violation or take corrective actions. I documented everything and left the establishment without any further issues.
Okay. After the August 12th incident, have you been back to the location?
Yes, I have.
All right.
No issues with trash.
No issues with trash?
Correct.
Okay. Mr. Nelson?
Yes.
Thank you.
Yes, there was about 4 or 5 trash cans outside because I have a trash removal person that comes and take it every day. But dealing with the public, everybody just dump the trash there once they realize that it's being removed. Once it was brought to my attention, I took corrective actions. I removed the trash can from the side of the building, and they're now in a fenced area in the backyard. So now the truck comes and pick it up from there.
Okay.
So we no longer have that problem.
So you've corrected everything?
Yes, I did.
Yes, that's great. Any questions?
No, no questions.
No questions? Okay. Based on the violation report, the testimony given today by all parties, I find that there was a violation of Rule 3.082, sanitation and safety, on July 2nd, 2024, and a violation of Rule 3.082 on sanitation and safety on August 12th, 2024. Looking at your record, you only have, I think, a restroom violation in the past. Yes. So I would issue on each of these a $250 fine for each of these violations, so it's $500 total, and you have 30 days to pay, given the fact that you've fixed everything.
Thank you.
Yes, based on material, the testimony provided today, and with the licensee remediating the issue, I also agree with the chair's findings of violation of Rule 3.82, sanitation and safety, $250 fine, and violation of Rule 3.082, sanitation and safety, with a $250 fine.
Based on the testimony given, I find for a violation of Rule 3.08, parentheses 2, sanitation and safety. On July 2nd, 2024, reference excessive amount of uncontained and improperly stored trash outside of the establishment. Also, for violation, there's another one here. Just let me find it. There you go. Also for a violation on August the 12th, 2024, I fined for a violation of I can't find the reference information.
3.082.
I have a hard time. 3.082 for that charging support. And I find the owner guilty, not guilty, but I find for violation. Y'all excuse me, please, I'm having a problem here, but I'll get it together. And, give me a second. Based on the testimony given, I find for a violation of 3.082 parentheses, sanitation and safety also for that violation. And I charge for both of those violations. One is $250 and the other is $250 for the fine. Did I address everything, sir?
Yes, you did. You did. You got it all now. All right.
It took me a while.
Executive Secretary Page.
Exhibits for the record. Exhibit number 1, violation report. Exhibit number 2, violation report. Exhibit number 3 through 7, photos.
All right. Thank you. Good luck to you. Thank you. Thank you.
Mr. Nelson? Thank you, sir.
Sean Connor, ISK LLC, trading as CNC Lounge, 4923 Reisterstown Road, Class BD7 Beer, Wine, and Liquor License. Violation of Liquor Board Rule 4.14, live entertainment without authorization. On July 26, 2024, a DJ was performing inside the establishment, although the establishment did not have permission to have live entertainment. Violation of Liquor Board Rule 4.073, open containers in illegal possession and consumption of alcoholic beverages, also on July 26, 2024, allowing patrons to drink alcoholic beverages outside, which is an unlicensed part of the property. Violation of Liquor Board Rule 4.073, open containers in illegal possession and consumption of alcoholic beverages on August 9th, 2024, allowing patrons to drink alcoholic beverages outside, which is an unlicensed part of the property. And finally, violation of Liquor Board Rule 4.052, prohibited hours on August 9th, 2024. They were open and operating past the 10 p.m. closing time. Please come forward.
Is this going to be admission?
There's a B, for the record, Melvin J. Kanensky, 320 North Charles Street. Being admission as to the live entertainment, we have some questions and I have some testimonies to the other violations.
Okay. Expected.
Excuse me.
I'm sorry.
It's okay. Inspector Jordan, Baltimore City Liquor Board. On July 26th, we went out to the location with the Social Club Task Force. We found that there was a DJ set up inside. People were dancing. He was speaking on the microphone. Then we noticed that people were walking outside to the patio area with drinks in hand. They were sitting outside and drinking. I spoke to Mr. Curtis, and he admitted that people do get drinks from the inside, buy them inside, and bring them outside to drink. That happened on July 26th. On August 9th, at approximately 10:12, Inspector Jordan and myself were in the area monitoring places that should be closed at 10 o'clock, and we were also following up at this location, and we noticed that the location was still open. There was people still coming out. They were drinking in front, and they were also drinking in the same patio area that we had observed them using on our previous visit. And that happened on August 9th. We made notice of that and, documented it and left the location.
And what time were they serving on that date?
On August 9th, we were there at approximately 10:12 p.m. We observed them from the outside. We parked across the street observing. And the location was still open. There was people still coming out, and the patio area was still being used.
Okay.
Well, it's good to start with that one there. Did you at any time on that date see them serve anybody or dispense it or furnish it? You just saw them with the possession of it?
Yes, I did,
Okay.
and I went by what Mr. Curtis had said on July 26th, that they do get the drinks from the inside and bring them
I'm
out.
talking about the prohibited hours. When you, on your prohibited hours, it says that they may not be served, dispensed, furnished, or given away. You don't have any evidence that you just saw them with possession of the alcohol, is that correct?
Yes.
All right. And number two, with regard to the alcohol that you mentioned, when you went there when they had the live entertainment, it seemed like it was a party going on, or there was a birthday party? If you don't know, I don't want to put words in your mouth.
I'm not sure if they were having a specific celebration.
And then in the front of the place is, and you have some pictures there too, I think mine are nicer, show the place, and in the back there's a patio area, is that correct?
Yes.
Okay, can I submit these? Okay. And the times, did you at any time take whatever the people were drinking to verify that it was alcohol?
No.
Okay, so you don't have any evidence that they were drinking alcohol, you just saw them with a container, is that correct?
Well, I did speak to Mr. Curtis, and he admitted to me that they buy it inside and bring it outside.
Yeah, but you didn't physically have any evidence of the people out there having a beer or have a drink in their hand that was you could confirm was alcohol?
No, I didn't test it.
And they were complying with you, is that correct?
Oh, yeah, they were very compliant.
Okay. I have no further questions.
Okay. So is it your contention that you saw people outdoors consuming alcohol, but you're saying that you didn't see if there were alcoholic beverages in their hand or not at the time?
They were gathered the same way they were gathered when I went with the social club task force. So,
Okay. And so I want to make a distinction. So on July 26th, that's the first time you went, correct?
yes.
And on that date, did you see persons with any beers or any type of alcoholic beverages?
They were outside with beverages, and I spoke to Mr. Curtis, and he disclosed to me that they do buy the drinks inside and bring them outside to the patio area.
Okay. All right. Any questions based on my question?
But you weren't able to verify that what you saw there was an alcoholic beverage, is that correct?
No, I don't know.
I mean, I'm not-
that it's a
I'm
bar.
not trying to be critical, I just want to,
It's-
we're here for a matter of burden of proof, and you saw them having something in their hand, but you weren't verified that they were alcoholic beverages, correct?
I didn't test it, but it's a bar, so I assume that they're buying drinks.
Do you ever do that? You ever test it when you walk up to somebody and say, what do you have in your hand?
I don't.
No, well, could you?
I don't like to.
I don't want to, 'cause
I
sometimes-
don't like to get the customers. That's their customers. I don't like to involve them.
That's a good approach, no further questions.
Any questions from the
Yeah,
commissioners?
is Mr. Curtis here?
Right here.
Could I, Mr. Chair, I'd like to ask Mr. Curtis.
You got to be sworn in. He needs to be sworn in before he says anything.
Is anybody else going to testify, Mr. Gibbons? Why don't you, can you raise your right hand as well? Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And then can you state your name? and spell?
Curtis Connor.
Okay. Just want to, regards to the inspector, that you did state to her that you do serve them alcohol and they take it outside, is that correct?
Sometimes they do, yes.
Okay, thank you.
I got it.
Okay, any questions, Commissioner?
But, yes, I do. I was gonna keep my mouth shut, but the door was open and you allowed the people there to go in and out of the building?
When I close at 10:15. The front door is locked. They leave out the back door. Whether they have something in their hand, sometimes I can't say yes or no to, but I'm closed. But they said that someday that somebody came out, and from what the reading said, somebody came out and came back in the yard. If they did, they came to close up. Nobody was in the yard at the time they talking about.
I'm not clear. At 10 p.m. that night, both the side and the front door, were they closed?
I'm not sure.
You're not sure?
Right.
All right, that's good, thank you.
Well, then, in response to that, it's a good question. You, at 10 o'clock, you close, so at 10
Yes.
o'clock, you don't serve, dispense, or furnish any alcohol at that
None
point?
at all.
All right, 'cause
None
that's
at
the,
all.
that's the rule.
Right.
Okay, I have no other questions. State's case? I mean, board's case, I'm sorry.
That's the court's case? Okay.
Yeah, so for the record, with regard to the entertainment, we have some mitigation, but with regard to Rule 4.05(2), it says alcohol beverages may not be served, dispensed, furnished, or given away when they're prohibited. We don't have any evidence of that there were any sales, furnishings, and that. And the illegal open containers and illegal possession and consumption of alcohol, although there's just some discussion occurring, we don't have anything for those particular dates and times that the person had alcoholic beverages outside the premises or in an area that wasn't permitted to have alcohol dispensed or be able to drink it.
And that's your argument on the August 9th date?
Well, they're on both days, they have that open containers.
So you're saying on the,
On both days, there's no testimony that what the inspector saw, the person had alcohol in an open container. There's just no evidence of that. Now, we've had the ones before where they would go over and they would say, they would give it the smell test and they could say it was alcohol, or somebody had a bottle of beer in their hand, which you don't have here.
okay. All right. I'm ready to make my ruling on this. Based on the violation report, the testimony that was given today by all parties, proffered made by counsel, I do see a violation of Rule 4.14, live entertainment without authorization, on July 26, 2024. For that violation, issue a $500 fine with 30 days to pay. I do see an issue with the other violations only because I think there's no verification on whether or not there were alcohol. So I don't find a violation on Rule 4.073 on July 26, 2024. Also, just from the testimony, I can't find a violation on Rule 4.073 on August 9, 2024, and on a violation of 4.052 prohibited hours on August 9th. I can't find a violation on that one just because, as stated before, testimony wasn't given that alcohol was served, dispensed, or furnished or given away on that date. I just can't do it.
So for clarity of the 4 violations, Mr. Chair, you ruled on just one violation, right? Of 4.14?
There was an admission on that, too.
There's an admission on the first one, yes.
Okay.
That is the one.
Okay. Based on materials and testimony provided today, I agree with the chair findings of violation of Rule 4.14, live entertainment without authorization, and a fine of $500.
Based on the testimony given, I find for a violation of Rule 4.14 on July the 25th, 2024, reference a DJ performing inside the establishment, and the establishment does not have permission to have live entertainment.
Now let me say something though on this. Does this mean that I think that there was no open container?
Well, and maybe I'll give you a little more up behind what this happened. First of all, with regard to live entertainment, it was certainly was having a birthday party, and a happy birthday. It wasn't so happy now for them, okay? They've been posting, and they'll have pictures where they have no open containers. They have posted all over the place, so you couldn't take them out, so it shouldn't happen in the future. With regard to the back patio, they'll probably ask for an extension so people, people come out in the back and they smoke and they take them out there. I understand what you're saying. I think forewarned is forearmed in this case.
So you know what I'm about to say.
Yeah.
Do I think that there was alcohol out there, maybe? Do I think that it wasn't proven today? And so I just want to let you guys know that's the only reason why you didn't get a violation on those other 3 is because the testimony just didn't support it. But, so you almost got a kind of a pass this time on that. So make sure you do the steps that your attorney said, because that normally doesn't happen. No, it doesn't happen at all. But I think this is a good warning for you guys, and I see you have no other violations in the past. So
It's been in the family since 2000.
I understand. They're good licensees. So. Okay, thank you.
May I finish?
Yeah.
Okay. Okay, I'm gonna start all over again, make it real fast. Based on the testimony given, I find for a violation of Rule 4.14 on July 26, 2024, a DJ performing inside the establishment when the establishment does not have permission to have live entertainment. And for that violation, I'd like to chair $500 with 30 days to pay. The other violation, again, was not clear. It wasn't a complete testimony, so I find that not guilty on 4.07, 3 parentheses, open containers, not guilty. That's on July 26th. Violation of Rule 4.073, open containers again on 8/9/24. Not clearly expressed whether it's a violation or not guilty. 8/9/24, violation of Rule 4.052, prohibited hours. Another step, you would have had him if he said he was having a party inside, activities. He didn't say that, so not guilty.
All right, Mr. Page.
Exhibits for the record, exhibit number 1, violation report, exhibit number 2, violation report, exhibits 3 through 5, photos, exhibit number 6, photo of establishment. Thank you.
Thank you very much.
Chin Sook Moon, River Moon, Inc., trading as G&T Liquor, 2048 Wilkins Avenue, Class A, beer, wine, and liquor license. Violation of Liquor Board Rule 4.052, prohibited hours, on May 25th, 2024. They were open and operating past the 10 p.m. closing time. Please come forward.
Go ahead, Inspector. Please raise your right hand, both of you, to be sworn in before we move forward.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
Identify yourself, please. Identify yourself, please.
Agent Chase, Baltimore City Liquor Board. On May 25th, around 10:30 p.m., while on duty, I, Agent Chase, noticed that G&T was open after 10 p.m. The law for certain parts of the 40th District states that liquor establishments must be closed by 10 p.m. I watched Mr. K. Moon serve several patrons until about 10:34 p.m. I informed him that he would be receiving a violation for opening after hours.
Please identify yourself for the record. What's your name?
Chin Moon.
All right. Are you making an admission saying, yes, you guys were open past that time? Okay. Do you have anything to say?
Yeah, my employee said that because it was Saturday and Memorial Day weekend, so there was a lot of customer in the store, and he was so busy serving customer that he didn't realize how much time had passed. So after this incident, I had my employee set an alarm 10 minutes before closing time to prevent issue like this from happening again.
Okay. You see, you've had another violation for prohibited hours in the past. No steps were taken before to make sure this didn't happen again?
No.
But you realize that there was a violation before, though, for prohibited hours?
One.
Once before?
Once, yeah.
Okay.
He was stocking up. I don't know what's going on.
Any questions from the commissioners?
No question.
No.
Okay. Based on the violation report testimony given today, I find that there was a violation of Rule 4.05, 2 prohibited hours. I issue a $500 fine with 30 days of pay.
Yes, based on materials and testimony provided today, I agree with the chair's findings. A violation of Rule 4.052, prohibited hours, along with a fine of $500.
Based on the testimony given today, I find for a violation of Rule 4.052, prohibited hours. And I find for a violation of $500, 30 days to pay.
All right, thank you very much. All right, Mr. Page.
Exhibits for the record. Exhibit number 1, violation report. Exhibit numbers 2 through 5, photos. Thank you.
Jamela Ferguson, DDFG Inc., trading as Jamela's Liquors and Cut Rate, 1831 West Mosier Street, Class A, beer, wine, and liquor license. Violation of Liquor Board Rule 3.02B, cooperation, on May 28, 2024, failing to cooperate with the Baltimore Police Department by providing the requested footage. Violation of Liquor Board Rule 3.033, records on May 28th, failing to provide employee records when requested to do so. Violation of Rule 4.234D, 3i, digital camera surveillance system, also on May 28th, for failing to provide BPD with footage requested in connection with investigation of a crime. Please come forward.
Good morning, Mr. Acting Chairman, members of the board. Peter Priebus on behalf of the licensed Jamela Ferguson. Also with me is Mr. Tony Ferguson, who, another family member that is at the premises.
It's just going to be an admission, Mr. Priebus.
We would admit to the 3033 records violation and deny the other two.
Okay, anybody's going to testify, please raise your right hand.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Okay.
May 28th at approximately, I'm sorry, Andy Perez, Baltimore City Liquor Board. May 28th, 2024 at approximately 6:30 p.m., I and Inspector Jordan met Chief Chris O'Malley's at this location known as Jamela's Liquor. Once at the location, I learned that Detective Potro from BPD was investigating a crime that happened recently in the area. He was trying to obtain camera footage from the establishment. Detective Potro was denied access to this camera footage. Chief Chris O'Malley also attempted to get the camera footage, but he told that the cameras did not work. Inspector Jordan and myself conducted an inspection of the establishment. Employee records could not be produced at the time of the inspection. I informed Ms. Theodora Curry that violations were going to be written for failure to provide employee records and failure to cooperate with BPD, BLOC, and surveillance cameras now working. Nothing further.
And you said the cameras now work?
I'm not sure.
You haven't been back since?
I have been back, but I did not verify that the cameras worked.
Okay. All right, anything else? Any questions?
Question, was Mr. Ferguson or Ms. Ferguson there when you did your...
No, it was just Ms. Curry there.
Just the employee?
Yes.
Okay. And so the violation is failure to cooperate in providing the footage, but they told you that there was an issue with the camera, right?
They told Chief Chris O'Malley that the cameras did not work at the time.
Okay. And the police did take the
TVR, that's correct.
They did take it. Okay. All right. Thank you. I have no further questions.
So initially, when they asked, did they know the cameras weren't working when they initially refused to cooperate, or?
It was two instances. BPD requested the cameras. They denied the access to the cameras. Chief Chris O'Malley attempted to get the footage, and they told Chief Chris O'Malley that the cameras did not work.
And that was the second time they went back?
Correct.
Okay. Any questions based on my questions?
Okay. Was that the same day?
Same day.
Okay. And
I believe BPD got there prior to Chief Chris O'Malley's. I got there later.
okay. And did you talk to Mr. Ferguson at any?
I did not.
Okay, thank you. No further questions?
All right. Do you have any testimony put on?
Yes, Mr. Tony Farley. Were you sworn?
Yes.
Okay. You are the day-to-day operator of Jamella's, is that correct?
Yes.
All right, and that business has been in your family since how long?
I think 40 years.
Okay. And did you have a camera system?
Yes.
Okay. And at the time, did you get a phone call regarding this incident?
Yes.
What was the underlying criminal activity that gave rise to the police asking for your phone?
It was a shooting on a Sunday, and I said, "Well, I'm not even open on a Sunday," and it was across the street. So I was like, and it's not in front of my building, and I wasn't open. But
You now understand, after preparing for this case with me, that the rule does provide that your cameras have to have 24-hour surveillance and that you are required to give that to the police. Is that right?
Yes.
Okay. And now, did you advise Mr. Chris Malice or anybody else from the police department about the status of your cameras at that point?
Yes.
And what was the status of the cameras?
I had somebody to put them up, and I think they put them up wrong, so they wasn't working.
Okay. And have you since rectified that situation?
Yes.
Okay. And you brought me a copy of a bank statement?
Yes.
How much did you pay to upgrade that system?
$2,600. Yeah.
$2,600 change?
Yes.
Fully operational?
Yes.
You know how to use it?
Yes.
You know how to provide it to the police?
Yes.
Okay. And with regard to the employee records, Ms., what's her name, works there?
Joel Carr, yes.
Okay, but you didn't have a folder with her name and last four digits of her social security number?
No.
You didn't, so we admitted that?
Okay.
You fixed that as well?
Okay.
Okay. Nothing further.
So
Any questions?
Yeah, you stated, you told your employees, though, to cooperate if there's
Yes.
any other
Yes.
investigations.
And as soon as I got there, I let them in, and they said we want it. I said, okay.
Okay.
No problem. She just was waiting for me to get there. That's all.
Okay.
So that's where the misunderstanding was.
So that's where,
Yeah.
but then now they know they have to do it even if
Man,
you're not there.
whatever they want, and like I said, when they got whatever you want to do, that's whatever.
Yeah.
I don't have no problems.
Okay. Any questions from the commissioners?
No questions.
Okay. It seems like you rectified the issue on these violations. Based on the violation report, the testimony given, proper made by counsel, I do see there was a violation of Rule 3.02B, cooperation, at least on the first time prior to you getting there, the licensee getting there. I see that there was a violation of Rule 3.033, records, and a violation of Rule 4.234D, III, digital camera surveillance system, with it not being in order and working and made accessible to the police department because it was not in order. Seeing that you have no other violations and that you made quick steps to make sure that everything was right after this, I'm only going to issue a $100 fine on each of these violations and give 30 days to pay. Okay?
Thank you.
Yes.
Mr. Chair, that's with each violation?
Yes, 100 each, yeah.
Based on materials and testimony provided today, I agree with the chair's findings of violation of Rule 3.02B, cooperation with a fine of $100, violation of Rule 3.033, records with a fine of $100, and a violation of Rule 4.234D, III, with a fine of $100.
I also agree with the chair findings. I find for a violation of Rule 3.02B, cooperation, and that fine is $100. Violation of Rule 3.033, and that fine is also $100. And violation of Rule 4.234D, 3 little i's. That fine is also $100.
All right, Mr. Page.
Exhibits for the record. Exhibit number 1, violation report. Thank you.
All right. Thank you. Good luck to you guys, and thank you for rectifying those issues.
Give me the one-on-one. Good to see you. Sure.
Joyce Young, 316 through 318 Guilford Avenue, LLC, trading as Iconic Assembly Room, 316 through 318 Guilford Avenue. Class B, beer, wine, and liquor arena license, violation of Liquor Board Rule 3.12, general welfare on July 27th, 24. The music was loud, so loud it could be heard several blocks away. Violation of Liquor Board Rule 3.12, general welfare on August 31st, 2024. Same charge, playing music so loud it could be heard several blocks away. On violation of Liquor Board Rule 3.12, general welfare on September 1st, 2024, playing music so loud it can be heard several blocks away. Please come forward.
Good morning, Mr. Acting Chairman, members of the board. Peter Previs on behalf of the licensee Joyce Young. I have here with me today Ms. Tracy Stafford, who is the full-time operator of the establishment and was present on the applicable date. Is that right? Yes. Thank you.
Is this going to be an admission?
Not guilty with an explanation.
So a half
Catch my-
admission.
catch my drift.
Okay, all right, go ahead. Everybody raise your right hand if you haven't been sworn in already. Who's going to testify?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
So, of course you do.
They have two members of the association here, too.
Okay. So, are you guys members of the community association?
Yes, I'm the president.
Okay.
And if you could state your name.
Wait, you have to come up over here.
Oh, okay.
Or at least say it loud enough so we can hear it for the record.
My name is Daniel Thompson.
Okay. And,
My name is Ted On.
okay, we're gonna get to you guys. But I want to make sure that I get to you before we finish this hearing, okay?
Mr. Chairman, I have just a technical point before we begin. There are two violations of 3.12 for August 31, 24, and the facts are repeated in both. I just don't see a separate incident.
Actually, it's July 27th, August 31st, and September 1st.
That's correct. There's 3 different dates.
I'm sorry, mine says August 31st twice.
Okay. So July 27, 2024, August 31st, 2024, and September 1st, 2024. Not the dates.
Was that updated?
I don't know. That's what's in the docket.
It's here, and here. Foundation here, foundation here.
And the next page. Okay. Do you need another docket?
I see. Well, the synopsis says August 31st twice. The notice that's served upon the licensee does have September 1st.
Okay.
Okay.
So, want to move forward? Go ahead.
Yes, I'm going to be testifying in regards to the July 27 violation. Agent Perez, Baltimore City Liquor Board. On this date, we received several complaints for loud music and violation of the terms on the MOU between the licensee and community members. At approximately 10:40 p.m., I arrived to the location along with Inspector Nasir to investigate these allegations. Upon our arrival, we could hear loud music emanating from the rooftop deck of this on the establishment. After making the observations, made my way up to the 3rd floor and made contact with the licensee, Ms. Tracy, the operator, I'm sorry, Ms. Tracy Stafford. I made her aware of the complaint received. She stated that the music was within decibel, agreed on the MOU, but she agreed to lower the music even further and stop all microphone use for the remainder of the night. We departed the establishment at approximately 11 p.m. At approximately 11:27 p.m., another complaint came in for the same allegations. We returned to the establishment at approximately 11:40 and advised Ms. Stafford that I could hear music several blocks away, 2-3 blocks, city blocks from the establishment, and that a violation for loud music was going to be issued. I could not establish a violation of the MOU in this case because The MOU specific talks about decibel levels. We're not equipped with decibel readers. It's just based on our judgment and what we can hear. Nothing further.
Okay. That was on July 27th. Who was there in July?
Me.
Go ahead, ask their questions.
Okay. All right, Agent Perez, you're aware that the MOU indicates that the maximum decibels for the rooftop is 58 decibels?
That's correct.
And that's at the end of the rooftop?
I didn't read that specific part.
Okay. But, okay, so you've candidly indicated you didn't have a decibel reader.
I did not.
You requested the health department but got no assistance there?
I did file a request to the health department. I don't know where that stands. I can name where I was stationed at to determine noise levels. The first location I responded to, let's see, my records.
If I could just interject just for a moment, Mr. Chair, they were not charged with a violation of the MOU.
Yes.
Saratoga and Holiday, 1 block away from the establishment. Saratoga and Gay, 2 blocks away from the establishment. Fallsway and Pleasant, about 1 block away from the establishment, and the 400 block of Fallsway. That's where the locations where I assessed the noise levels. At each of these locations, I could hear the music clearly and loud.
Okay, you could hear the music?
Yes.
Okay, so if they're permitted to have 58 decibels on the roof at the end of the rooftop, then how do you assess whether there's a violation of disturbing the peace where it's perfectly legal for them to have 58 decibels at the, on the rooftop?
As I didn't assess level at the rooftop, I assessed the music level blocks away from the establishments. That's where I was looking for noise, and I could hear it loud and clear.
Okay, so is it a violation to be able to hear the music, or is it a violation that the music is at such a level that it would be disturbing to someone?
It is a violation where the levels of the music disturbs the community and neighbors of the establishments.
But you didn't hear that. You said Holiday and Saratoga?
Saratoga.
Okay, so this place is on Guilford between Pleasant and Saratoga?
That's correct.
Okay, and so you're saying Holiday being
1 block.
where? 1 block over?
Yes.
You could hear the rooftop?
Yes.
Okay, and what were you hearing? Were you hearing people talking? Were you hearing music?
I heard music, and I hear people on the microphone shouting.
Okay. All right, and then what were the other locations?
Saratoga and Holiday, 1 block away. Saratoga and
Go
Gay
slow.
Street.
Saratoga and Holiday, we did
Yes.
that one.
Saratoga and Gay, that's 1 block over from Saratoga and Holiday.
Okay.
Fallsway and
All
Pleasant.
right, let me stay there. Now, when you're at Saratoga and Gay, do you know where the sound is emanating from?
It was
There's people in cars.
It was emanating from the rooftop.
Okay.
It was the same music at each location. As I got closer to the establishment, it was same music, same pattern, all the way till I got to the
Okay,
establishment.
so you indicated that you ruled out somebody playing loud music in their car in the parking lot, something like that.
The music was emanating from the rooftop.
Okay, all right, so where are the other 2 locations?
Fallsway and Pleasant.
Fallsway and Pleasant, so that's on the other side of the farmer's market parking lot,
Correct.
right?
Yes.
Okay. And when the farmer's market's going on Sunday, and there's a lot of people there, okay, are those people disturbing the peace because you could hear them?
I've never been to the farmer's market, sir. I'm not sure what the noise level is at the farmer's market.
Okay.
How does that play?
Huh?
Okay.
All right, thank you.
All right, look at,
No further questions.
yeah, can we move on to the next violation date?
Inspector Jordan, I am here to testify pertaining August 31st at 9:45 p.m. Myself and Inspector Todd Hope were driving around, returning to the office. We approached the light at Pleasant Street and Guilford Avenue, and we could hear music coming from the rooftop. We made a call to the agent in charge, Agent Perez, who instructed us to assess other areas to see if we could hear that music. We parked at 300 Falls Way, which is approximately 1,100 feet away, and we could hear amplified male voice and the bass coming from the location. We went on to Saratoga Street, which is 550 feet or 2 city blocks away, and we could also hear the music coming from the rooftop. At that time, approximately 10:15, 10:19, a 311 complaint came in for loud music. Inspector Todd Hope, along with other of my team members and the chief, responded and issued a violation. They took over from then.
Thank you. So again, do you know the genesis of the 311 complaint?
Loud,
No, I mean,
disturbing.
who was it?
I am not sure for this particular one who called it. Who called it.
It wasn't liquor board staff, it wasn't police?
No, it was a community member.
Okay. All right, so again, you are aware that there is an MOU that authorizes 58 decibels at the perimeter of the deck, correct?
Yes.
Okay. And so, do you have some type of rule that if you're 50 feet away from the premises, that it's a violation if you can hear the music?
If it's disturbing the neighbors, it's a violation, and we parked at numerous locations and assessed it, and it was loud.
Okay, so who was disturbed?
The people complaining, the 311 complaint.
Okay. You don't know that?
Well, we've gotten numerous complaints there.
Okay, but you can't assess the validity of a call that didn't come to you. You didn't meet with anybody that night.
No, I don't
You
think
didn't go to
so.
their apartment window with them or anything like that. Thank you.
And I would like to add that we have a recording of what we heard that day,
Okay, go
that
ahead.
night.
Okay, you gotta do it this way so you can see also. And where, before, stop it, where is this located first?
Oh, Meg. I believe that is the Saratoga and Holiday.
We can see Holiday,
Can you identify yourself?
Yes, my name is Zane Desir.
Okay. Can you see it, counsel?
Yes, so you're at the other side of the parking lot.
I believe we could see the establishment in front of us.
Okay, go ahead and play.
Give me a second click.
And where is this location?
Madison.
So tell me what time it was played and where was it, for the record? Yeah.
That would have been between 9:45 and the time the complaint came in, which was 10:19.
Okay. And the location?
That was, I believe, the,
Looks like it's on the side of the parking lot.
yeah, I believe we have the parking lot. We could still see the establishment in front of us. So
And-
I believe Saratoga also.
And there was another location that you witnessed the sound that was on the other side of 83. Is that the Jones Fall Trail?
The Falls Way, 300 Falls Way.
100 Falls Way. And that's what, like 3-4 blocks away?
1,100 feet, so maybe 4 blocks away.
Okay. All right, any other questions based on my questions?
Is there some type of uniform standard that the liquor board applies with regard to other establishments in Baltimore City that have outside music playing?
Other establishments or this establishment or in general?
One guideline that's applied equally to everyone.
Once we receive a complaint, we go out, if it's loud and a community member is complaining, and we park far enough where it shouldn't be heard,
And what is that standard?
if it's disruptive to the community.
Okay, so you get a complaint, that someone, whether they are reasonable or going to be disturbed by anybody we don't know, and then you go out and listen for music on the exterior of the premises.
Yes.
Okay,
That's what she said, though. She said the same thing multiple times.
okay. And you apply that equally across the board to every establishment in Baltimore City?
Yes.
Okay. All right. So
Good enough.
on the third violation, any questions before we move on?
No, no.
Third violation is on September the 1st. Which agent was that? Okay, go ahead.
Agent Chase, on September the 1st, 2024.
Chase, I'm sorry. Get in front of the mic, please. Thank you.
On September the 1st, 2024, a 311 complaint came in at Iconic for loud noise and disturbing the peace. I parked 300 feet away on Falls Way, and then I went to Holiday in Saratoga and sat there, which is approximately 2 blocks away. And from both, I could hear loud noise, I could hear music, and I could hear an amplified man on a microphone. While I was at both locations, I took video proof of where I was, and Inspector Brown met me inside, and we informed Ms. Tracy that she would be receiving a complaint for loud noise and disturbing the peace.
Okay, so September 1st is a Sunday. What time did this occur?
The complaint came in at 9:24. I sat there and observed until about 10:45 until I went inside.
PM?
Yes.
So it's not the same incident as the night before going
No.
into the next day?
No.
All right, and where was it was music?
It was music and a man amplified on a microphone.
Okay, and where was that coming from?
The rooftop.
The rooftop, okay. And did you do any decibel readings?
No, we don't have decimal machinery.
Okay, thank you. I have no further.
And I have video proof.
Okay, go ahead. And before you play, can you just identify where the video is taken?
So the first one is from Falls Way.
This is across 83,
Yes, across the highway.
across the highway.
By like the homeless shelter.
Okay.
The second one is at Holiday and Saratoga.
All right, any questions?
Thank you. So, again, does the Raven Stadium have a liquor license?
Yes.
Okay.
That's not
It is.
related to
I'm
this
just trying to make my point about
hearing,
the
but we have
standard.
to move forward.
So Lamar makes a fantastic throw and we get a touchdown and the whole place goes up in a cheer, right? And you can hear that from the other side of Lot H. Is that disturbing the peace?
That's not relevant.
Okay.
Did you file a complaint about it?
If the Redskins scored a touchdown, yes, I would.
Okay, can the community members come forward? Do you have anything you would like to say?
Huh?
Just identify yourself before you speak.
Go ahead.
Okay. Hello, my name is Daniel Thompson. I represent the Berkeley community at 234 Holiday Street. Just for going forward, everything that I talk about will be at 234 Holiday Street, for there's no confusion. Just to start off, I did a little bit of research, and the standards for environmental noise in general says anything commercial at night is 62 decibel, and during the day it is 67. I just want to say that this has been applied on the community. Sorry, my voice is shivering because this bothers me. I have tinnitus. At night, we have people complain. I'm the president. I'm up at like 11 o'clock at night hearing this, 2 a.m., seeing what is going on, why is it loud, what is going on. We had multiple times that we have tried to communicate with them. Just to reiterate, we have an MOU with them that was signed on April 24th. And just to make sure, sorry, I have the MOU up right now. What is the email to Tracy Stafford?
Just testify now, you can.
Okay, just testify. We have made multiple times to contact them. It is in violation of their MOU that they signed. It is, sorry, I have to bring it up. Agreement A, Agreement 1C, and it states, establishment will identify at least one contact person to receive communications from the council of the unit owner of the Breckville community, Inc. At all times of this agreement, the contact person for the establishment will be Ms. Tracy Stafford, and the phone number is 410-9.
Okay.
Okay, so basically, we have made multiple attempts to communicate that they have been a disruption to the community. They have never replied. We had to reach out to them by phone, no communication. It took one of our own people to reach out to them and go there personally to verify why is the music so loud and can we turn it down.
Matt, have you been involved, Matt? I'm sorry to bring you involved. I just want to.
Oh, no, that's perfectly fine.
Just identify yourself.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, whole truth, and the truth?
Yes. Matt Ockheimer, Community Liaison for the Liquor Board.
Just a quick question. I just wanted to make sure that you guys are in contact with each other.
Okay.
I will make sure that we are moving forward. I have been tangentially involved in the past, sort of getting them all connected to each other, but not directly with the discussions of the MOU.
Okay. That's all. I just want to make sure that before you guys leave, that you guys connect, so we do have a liaison that can make sure that everyone is on the same page, at least.
Okay.
And can communicate, okay? All right. Now,
We'll remain after we make sure we.
you'll do that, okay. With respect to the dates herein, did you have anything to say about the July 27th, the August 31st, or the September 1st dates?
Let me check my notes. I do have notes. On July 27th, okay, I believe we do have a decibel reading. However, as unfortunately it's not for these dates. This has been an ongoing issue, and we have been.
I do have a decibel.
Oh, you have a decibel reading? Okay.
Well, I took a decibel reading on
Okay.
my phone, so.
Okay, we're not the health department. We have tried to contact them multiple times. However, I don't think they're going to come out at like 12 a.m. to verify the. But what was the decibel reading that you?
Are you finished with?
Oh,
I'll
yes.
have him come up.
I'll let
Okay.
him go.
Thank you for your
Yes.
testimony.
I have no questions.
You have no questions for him? Okay, come on, and please identify yourself first.
My name is Ted On. I live at 234 Holiday Street, one of the residents at Breckville Condominiums. So I have a decibel reading for July 27th. This is at around 9:20 p.m., and it's about 70. The average, and this is just from my phone. It's a free decibel reading.
Hold on one second.
How do we verify the authenticity? Is he using A, B, C readings?
I understand, yeah.
I understand his point, but I don't think it's.
We won't use the decibel reading from the phone as a reason for our ruling. But go ahead, keep testifying.
Yes, I mean, this is what we have access to. This is a decibel reader, and this is what I'm testifying with. So an average of 70 decibel. Remember, the decibel readings are logarithmic, so the higher you go, the higher it is, which is far past the 61 decibel reading or 58 that we agreed upon in the MOU. So this is what we kind of use to say, okay, this is too high. I'm going to submit a 311 complaint. And then I've done this multiple times. Another time it was a 73 decibel reading, and our building is literally just across from this venue. Catty corner from the parking lot. So I also have videos, and it sounds just like what the inspectors presented to you. So it has been, I mean, we are representing a community of 32 units, and there are a lot more people that are impacted by this. Obviously, in the middle of the day on a Thursday, they are out to work, so they are not able to be here to testify. But we are representing a whole lot of community members that live in downtown that are impacted by this every weekend nights. And, you know, folks are not able to sleep, and some of them are, you know, physically impaired. Some have issues, you know, with the noise, and it's really impacting individual members of downtown community. And it's not just our building. There are other apartment buildings, and of course those are renters. We are permanently, we're a condo association, so we're kind of permanently there. But for these renters, you know, they'll probably just move out and not get involved in this process. But I'm sure they are also impacted by it. You know, at our first hearing, there was a member, I don't know if you remember, was very emotional about it. So again, I really hope that there is some sort of resolution, and you hear that, and I'm glad for there to be some official kind of recount and documentation of these violations. Again, with the decibel reading, that's just an MOU between us two, but it looks like there is a general violation of general welfare. So that's my testimony. Thank you so much.
Thank you for your testimony. Thank you. No questions? All right, go ahead, Mr. Cruz.
I'll call Ms. Tracy Stafford. This is somebody's. Ms. Stafford, are you sworn?
Yes, I am.
Okay. Are you on site most, all of the time?
Most of the time, yes, I am.
And were you there on July 27?
Yes.
August 31 and September 1?
Yes.
Each of the 3 times?
Yes.
And you met with the liquor board?
Yes.
Officials that came out?
Yes.
Okay. And did you turn the music down?
Yes.
Okay. And have you been receptive to any, your cell phone number is in the MOU?
Yes.
Have you received calls?
No, I have not received any. I would love to see a phone log of that, because I always answer all my calls.
Okay. And you also have an email address?
Yes, I do.
And you will make that available to the members of the condo association?
Yes, I just gave it to the president, my phone number again, just in case.
Okay. And not that it matters much, but when does the outside deck end for the season?
We have 2 more events this month, and we're done.
Keep your voice up.
2 more events in October, and we're done.
Okay. And you had also attempted to reach out through the downtown partnership to
Yes.
mediate?
Yes, we did.
All right. And you had agreed to the MOU for 58 decibels at the perimeter of the exterior of the upper deck, is that right?
Yes.
Okay. And it was your understanding that if it was 58 decibels there, that some sound would go past the border of your building, is that right?
Yes.
Okay. The complaint is someone on the microphone and low sounds. You understand that?
Yes.
Okay. Are you tell the people to turn it down?
Absolutely.
And how does that play out?
Well, normally if they come by, of course, we turn it down, you know, but I've been out front with the liquor board, we could barely hear it in front of the door. I think what's happening is bouncing off, because it's an open area, so there's no buildings in front of us.
Okay.
But when you're downstairs, you can't even hear the music.
Okay, so but if you're across the parking lot.
That's the issue.
It's carrying?
It's carrying, because it's nothing there, it's all flat land.
Okay. Are you amenable to investigating certain methods of
I'm very open to anything.
batting that sound?
Yes.
Or directing those speakers?
Yes,
so that
I am.
You don't get that? Okay. Have you been across the street from the farmer's market? When you drive in and something's already going on?
I can't recall, I usually come through the back area, I don't come up the front.
But have you ever gotten to your establishment and noticed that it was so loud that it would have been disturbing.
To be honest, I'm always there before it starts, so I'm never usually outside the building after the event starts.
Okay.
Yeah.
Are you-
Unless they call me downstairs.
All right, so you're going to represent to the board that you're going to do that now? You're going to do your
Absolutely.
own
I
preemptive?
want to be a good tenant. I also want to recognize, too, that I'm able to open 7 days a week. However, I don't, out of consideration for those who have to work. So instead of I lose about 5 days a week of business just to be a good neighbor and just open on the weekends. There's nothing in my MOU that states that I have to do that. I just do that in good faith.
Okay. Thank you. I have no further questions. The board may have some questions.
Okay, you have any questions?
No, I'm glad to hear there's consideration on both sides. Appreciate that.
Thank you.
No question?
No questions? All right.
Nothing further, Mr. Chairman.
Nothing further? Nothing further. I'm ready to move forward on this one. Violation of Rule 3.12, General Welfare. I do find like there's a violation of the Rule 3.12, General Welfare on July 27th, 2024, on July 31st, 2024, and on September 1st, 2024. What I do see, though, is that there's been no violations in the past. But I do see that the community really, really wants to make sure that you get a hold on this issue before it gets out of hand. And I know it's going to die down over the wintertime because the deck is not going to be utilized. But I just really urge Tracy to be more proactive and work with Matt and work with him to make sure that that doesn't happen again, especially going into next year when your business that needs to make money in the city, but also the community needs to be able to go to sleep and to be able to not be disturbed. I do find that there was that the music was too loud on those dates. I am going to issue a $200 fine on each of those, so a $600 fine because it's the first violation. But I do want to also note that there was no MOU violation. We want to make sure that that doesn't happen in the future. And I think that Matt, I think he said, I think he's going to kind of make sure that you guys can talk more. And over the wintertime, hopefully you can put some type of barriers up that this sound does not carry, because it's carrying all the way over 83. So I think that's the part that got me. It's not just a block or two away, but it's carrying a long distance. So I think you guys will be able to figure out a way to stop that from happening in the future. And in 30 days to pay the $200 fine for each of those.
Yeah. Just want to say, Mr. Chair, that's the size of a football field in regards to the noise, by the way. Based on material and testimony provided today, I agree with the chair's findings. A violation of Rule 3.12, general welfare, a $200 fine. A violation of Rule 312, general welfare, $200 fine. And also a violation of 312, general welfare, with a $200 fine.
Based on the testimony given here today, I find for a violation of Rule 3.12, general welfare, $200 fine. Also fine for a violation for Rule 3.2 again, and this one is August the 31st, $200 fine. And the first one I gave was July 27th, that's a $200 fine. And the last one was September the 1st, 2024, that's a $200 fine also. So in total, it's a $600 fine.
Yeah, 30 days to pay. And
30 days to pay.
And again, the reason why the fine is at the $200 fine level is because this is your first offense. If this keeps on happening, obviously, we're going to have to do other measures. Ms. Page.
Exhibits for the record. Exhibit number 1, violation report. Exhibit number 2, violation report. Exhibit number 3, violation report. Exhibit number 4, service summary. Exhibit number 5, service summary. Exhibit number 6, service summary.
Community members, thank you for coming out here. Yes, go ahead.
So,
Could you approach the mic, please?
Yes. To prove that, my name is Ted On, at 234 Holiday Street. So to prove that the establishment has violated the community MOU, what must be done?
Those
to that?
questions can be taken up with the liquor board. You can go to the
Okay.
office and have those conversations, and they'll explain to you what needs to happen.
Okay. Okay, thank you.
Thank you very much.
Thank you.
Thank you.
Sabota Bilas Panta and Prabhat Young Thapa, Suraksha LLC, trading as Sweet Carolina Liquor, 309 South Broadway, Class A, beer, wine, and liquor license, violation of Liquor Board Rule 3.12, general welfare, on June 11th, 2024, for selling miniature liquor bottles, single beers, and malt beverages in violation of the MOU with Upper Fells Point Improvement Association, violation of Liquor Board Rule 3.12, general welfare, on September 11th, 2024, again, selling miniature liquor bottles, single beers, and malt beverages in violation of the MOU, violation of Liquor Board Rule 3.12, general welfare, on September 13th, 2024. Again, selling miniature liquor bottles, single beers, and malt beverages in violation of the MOU with Upper Fells Point Improvement Association. And finally, violation of Liquor Board Rule 3.02A, cooperation, on September 13th for failing to follow instructions given on June 11th and September 11th, 2024 to cease sales of restricted items. Please come forward.
For the record, Melvin J. Kadensky, 320 North Charles Street, representing the licensee. Be a denial.
A denial. We have a lot of denials going on today.
Well, that's the river in Egypt, isn't it?
on a heavy docket. That's the way it goes. Okay, anybody that's going to testify, please raise your right hand.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make should be the truth, the whole truth, and nothing but the truth?
All right. Agent, excuse me.
I'm sorry.
Let's get up.
Share the space. Agent Perez, Baltimore City Liquor Board. On 6/11/24, approximately 8:15 p.m., per instruction of Chief Chris O'Malley, I responded to the establishment known as Sweet Carolinas to investigate a violation of terms of restriction on MOU. Sale of miniature liquor bottles, single beer, and malt beverage. Upon my arrival, I was served several shelves stocked with these products. I also observed several coolers stocked with these products. I made contact with the person in charge for the night, Mr. Krishnad. He stated that all miniature products and single beer were in the process of being removed. I did observe several boxes filled with this product at the time of this inspection. I advise.
Can you stop for 1 second? Are you interpreting or?
Yes.
Okay. I didn't know that. So go ahead. I don't mean to.
State your name.
Kiran Panta, Kiran Pantha.
Okay, so can we slow down? I want to make sure that the interpreter can interpret correctly, okay?
I advise Mr. Krishna that a violation will be issued for failure to abide by the terms and restrictions set on the MOU dated 12/1/23 between the Upper First Point Improvement Association and the licensee. You have any questions about that?
Yeah. Can I?
Yes, go ahead. You have any questions?
Etsy Ariadam, though. What memorandum of understanding are you referring to?
The one you have in front of you.
Which one do you have in front of you?
I have the same one. Just bear with me 1 second. Memorandum of understanding.
I see what you have. The question is, that memorandum of understanding was not on the original license, is that correct?
I don't know that information.
Well, I'm going to show you original license when it was transferred. Do you think this is from the records of the liquor board?
Yes, sir.
I'm sorry. The licensee in this case is an LLC, correct?
Yes.
That LLC is not a part of the memorandum of understanding, is it?
is between the licensee and the community.
But not the LLC that owns the license.
He's the license holder.
Do you now understand that the license is held by the LLC? You understand that?
That's correct.
Okay, and that's who owns the license?
Correct.
Okay, and that's not a party to this memorandum?
I don't know that information.
Well, if you look at the last page, tell me if the LLC signed.
Is this an exhibit, Mr. Chair?
I'm not sure yet.
It's out of your records, yeah, I'll make an exhibit.
Until
Memorandum
he
of
says,
understanding signed by the licensee and the president of the community association.
But not the LLC.
I don't know if he's the owner of the
It's
LLC.
just, it's a simple question. It doesn't have the LLC.
I don't know the answer.
No, but
He's
you have
answered the
paper in front
question.
of you.
He's answered the question. If there's evidence you want to show, you can
I'll
can
give
show
you a
that.
copy of the alleged memorandum of understanding.
And is this an exhibit that?
Yeah, I'll make an exhibit, you can refer to the last page.
Including the license?
Yeah, please. All right.
So what's your
And-
reference?
The question is, that's the memorandum that you're referring to, correct?
That's correct.
Do you have any idea when that was put on the license?
I believe it was done at the time of the transfer. I don't have the date for that.
So the day of the transfer is what I gave to the liquor board today, and it was, if it was not on there, that'd be a fair appearance of the license, is that correct? Did you check to see when it was put on the license? I'm not trying to get through it.
I don't have that answer, but I know the 2024-25 license states that the terms on the MOU are part of the license.
That license was transferred 2 years ago, and it was not on there, and it's on there now. You would have to have been added sometime thereafter, correct?
Possibly.
All right. And you're familiar with the terms of the MOU?
Yes.
All right, and we refer you to the MOU, and not stating the MOU is accurate. What does, if there's a dispute, what does the community have to do? Do you know?
I'm not sure.
Okay, well, I mean, you say you were familiar. I'm going to point it out to you. That on page 4 of the alleged MOU, do you have it here with you?
Yep.
In where it says community organization responsibilities,
Yes.
and if you go down to the last one, this, it will attempt to resolve any conflicts with the licensee at least 14 days prior to making a complaint. Do you know that that was done or wasn't done?
I'm not aware of when the complaint was filed.
All right, so you don't know whether they even did that, try to work any conflicts out with the licensee, correct?
No, sir.
Okay. So even if this was an MOU, that would be a violation of the terms of the MOU?
Yes.
Okay. And prior to this license that was issued in May, had you ever inspected the place before that?
I did.
And prior to that, as far as you know, there was no MOU, correct?
At some point, there was an MOU. Prior to the license transfer, there was no MOU.
Okay, all right. I have no further questions.
I'm going to testify in regards to the 9/11 violation. I returned to the establishment because we received another complaint that the establishment continued to sell these restricted products. On my arrival, approximately 10 o'clock p.m., I observed these products again on coolers and shelves. Mr. Krishna at this time told me that they were only selling premium miniature bottles for over $4, and he was in belief that this was allowed by the terms on the MOU. I also observed several coolers filled with single beers, cans, and bottles. I observed handwritten signs stating that single beers, bottles and cans of single beer were only sold in quantity of 2 or more. I advised Mr. Krishna that this was still in violation. I told him that I would be providing a copy of the MOU that I will follow up in the next few days.
So once again, you are try to enforce the alleged MOU, is that correct?
Correct.
And your authority to do that is under what? How do you get authority to enforce the MOU for a community group?
Article 2B.
Huh?
Article 2B.
It says that you can enforce. Are you sure it says that?
Well,
No, I'm just saying, he's saying yes, he's saying no, I just want to make sure. We're making a record there.
Yes, I can.
Okay. And then once again, there was no indication here that they tried pursuant to the alleged MOU to resolve this, is that correct?
Correct.
Okay, all right.
the next date is what, September 13th?
September 13th, approximately 10:40 p.m., I returned to the establishment to provide a copy of the MOU. As noted on my prior violation, at this time, there was a line of customer trying to pay for the products they had just purchased. I observed at least 2 sales of single beers. I also observed several brands of miniature liquor bottles on the shelves. After making this observation by Mr. Krishna that a violation will be issued once again for failure to comply with my prior instruction and to continue engaging in the sale of these restricted items.
And on the last one?
That's the last one, 9/13th.
But there was a cooperation?
Yes, the cooperation will be because he failed to remove these items as per my prior instructions.
Okay.
Per your instructions concerning this alleged MOU.
Correct.
All right. Now, you've read the MOU.
Yes.
All right. And on this MOU, it refers, this memorandum of understanding is given with regard to him picking up an A7 license if he gets a BD7. Is that correct?
Yes.
He doesn't have a BD7 or A7.
No, he has a Class A license.
Class A license, which is issued pursuant to the date, I think it's the 22nd, 2021 or 2022. Whoops. In 2022. Correct?
Correct.
And in this memorandum of understanding that you went through, an A license is a liquor store license, correct?
Mr. Chair, if I could just interject just for a moment.
Yes.
The reason that it was charged this way is because during the 24-25 renewal cycle, we received an email wherein the licensee agreed to make this MOU a part of his license during that renewal. We have the email if you wish to see it, but that is why that this was charged in that manner.
That would be helpful for the file, for the record, if we could have it.
You can continue.
I think the board says they have, it wasn't sent to me.
Okay.
Mr. Kandinsky, it was sent to you.
No, but it wasn't addressed to me as an email. I wasn't part of the email, it was an email chain, is that correct?
Well, do you have any other questions? And we'll see if we can pull the email up.
And on this memorandum of understanding, you went through about the promoters, outdoor table service, valet parking, karaoke, DJ, dancing, dance floor. None of that applies in this case, is that
Doesn't
correct?
apply to the current license.
Okay, and then it would only apply possibly to a BD7 if they got it, correct?
Possibly.
Okay, I have no further questions.
All right. You have any testimony you'd like to put?
No, I want to try to set this straight here a little bit if I can. And I'll proper as much as I can, unless you want to go through a torture of have an interpreter. Sometime in the end of December of 2023, Mr. Panther, who otherwise was a good licensee, approached the community about if he would get a BD7, whether they would agree to allow him to get an A7. There was a meeting and they said yes, and they got this memorandum of understanding only with regard that if he would get a BD7 to create to an A7, that he'd be bound by those terms and conditions. Number two, that sometime thereafter, before the renewal period, there was a email chain which Ms. Wurzberger will probably give us a copy to put in the record. Somehow in the meantime, it came in there that he had given an indication that he maybe would agree to this memorandum of understanding be put on there now, not in the future. I can tell you right now by talking to him through the interpreter, he had no idea what that meant. Subsequently thereafter, I had a conversation, and I think with the board, Wendy Bozell, who was then on there, indicating that when the MOU was created, it was understanding it wouldn't be totally effective until he get his BD7, his 7th.
Where does it say that on the MOU?
It doesn't say that, but here's the MOU, here's from Wendy Bozell, who was, oops, I'm sorry, I got one for each one of you. She was here today. She works for Kennedy Krieger. She could not stay. She would have been testifying. And she was.
If I could just interject, Mr. Chair, on page 5, what Mr. Kadensky is referring to is at the bottom of the page under entirety of agreement, it says, "The parties agree that the terms and conditions of the MOU become binding on the parties as of the date of their respective signatures. The sole exception being clauses regarding days and hours of operation, which become binding upon acquisition of the license by the licensee."
Yeah.
Yeah, they're all referring to a BD7 and an A7, not the A license on this case, because it wouldn't make any sense to go ahead and do that. And I think Ms. Bozell would testify that he had no understanding of what that email was, and I can put him on, and we'll wire dear him through the whole thing. Secondly, there was no, even if you took that MOU to be accurate, A, wasn't entered into by the LLC that owns the license. And the case of Rosedale Plaza indicates that the, I'll put this for the record, that the legal entity owns the license, not the visual licensee, in order to bind the licensee in this case. And in addition, there too, even if you follow your MOU, there's no testimony that they made any attempt to try to resolve the issue. And if you look at Ms. Bozell's email that I got this morning, last night, is that she was there and said she feels that he had no understanding about adding that MOU to that chain, and that they would probably not just dissolve this MOU and try to see if they can get a new one together. And I just think that to do otherwise would, first of all, not be in, the memorandum of understanding is of no effect because it doesn't have the LLC in it. And you've got to have that entity to go ahead and to bind the business. Number two, there was no attempts in there indicate there was any meetings, even if you went under that, to try to resolve any conflict. And number three, Ms. Bozell's email that came, actually came this morning, 6:16 to me, that there was no intention, to have that added to the current license. It was only for the BD7, which would be, if he could get a BD7, to get an A7.
Okay. Any questions from the commissioners? Is that your order?
No.
Yeah, just one clarification. So it was the MOU was with the licensee who had the trader's license occupancy permit, not the
No,
LLC.
he does
Was
not.
the LLC?
LLC has the license, trader's license, UNO, and then the health department licenses. That's the entity that is the business. LLC is held, or a corporation, through any officers who are licensees, but they're not the owners of the business. That's the Rosedale Plaza case, says that.
Is Mr. Panta the owner of the LLC?
He is one of them, but you would have to have, consent of everybody to go ahead and make sure the LLC, if you look on the license, there's more than one person that's on the license.
Yeah, but he could be an authorized
But we don't know that.
signer.
Yeah, well, you don't know that, and normally you would have to have that. So I think in this case here, my argument is, this was just a big mix-up between what he wanted to do and how to go about it. And he said, I'll do this if I can get a BD7, which is no guarantee, to ask for A7, and the community would say, okay. Somehow he went to this meeting, and Ms. Bozell said she was there, and she said that it was, the understanding is that it wouldn't be effective until he received his 7-day license. she was a representative. She was going to testify here today, except, you know, she's works for Kennedy Krieger, and she could not stay. You know, I saw her sitting in the back with me for a while. I can verify it through the interpreter, because she had said that was the same thing. So I just think it's one, it's not effective. Number two, they never followed the MOU to resolve any conflicts. And three, was not intended to be in effect.
Okay.
I mean, the MOU is not to serve miniatures or single containers. So someone, I might be rude, someone had to stock those refrigerator units in the shelves with single
They had that before. He had that.
Without.
Yeah, but he had that before. He had no restriction on the license in 22. You can look at your records in there. There's no restrictions from 22. The first time it ever shows up is on the renewal.
Yeah, but he should have took those down and did what he was supposed to do.
But he had no reason to do it.
That was part of the MOU.
Yeah, but the MOU is not effective. The MOU is for the BD7, then we get to the A7, not for the A license, and all the things in the MOU, if you read them about live entertainment, it makes no sense at all. And number two, that if you follow the MOU, then they're supposed to try to resolve the conflict before they even bring it to the board. And if you violate that part, it's what they call a sine qua non, that without which there's nothing. You can't start here and get here if you didn't follow your own MOU.
Okay. All right. Any other questions?
No.
Any other questions? No. So, all right. As to Rule 3.12, general welfare, and there are three of those. One is on June 11, 2024. The next one's on September 11, 2024, and the third one is on September 13, 2004. I do find that there was a violation. I'm going to give you my reasoning behind it. I understand your argument, and it was a good argument. But I do find a violation of Rule 3.12, general welfare, on all three of those dates, and a violation of Rule 3.02A, cooperation, on September 13, 2024. Our records do show that on April 22nd, 2024, that an MOU between the Upper Fells Point Improvement Association was added during the 2024 and 2025 renewal license year. The MOU was in effect. I understand if this was a contingent, if there was a contingency to it, and you know.
Well, if you read right in the very beginning, it does say that. It absolutely does say that. And if we might as well get it in part of the record, and say in consideration of him getting approval for a BD7. It says it right in the very beginning.
No, acquisition of a liquor license. It doesn't say that in the first line. And so you're going to use the consideration. That's not what this says. And I've read through this, and you know, I draft contract. This, it would be clear as a contingency to say that this MOU would not be in effect unless a BD7 was issued. And it doesn't say that in here. Even the signature line is of Mr. Panta, who is a member of the LLC. So
it does say that, though, for the record. It says, in consideration of favorable support and endorsement, the Fells Point Improvement for the acquisition of a liquor license. He already has it, so he's not acquiring anything. It really refers to the BD7 on the case. So this doesn't help with regard to the acquisition of a license, because he already has the license.
it doesn't say of a new liquor license.
It does, it says in
of
later
an
on.
acquisition of a liquor license, and I'm making my ruling now.
Okay,
but
no, I understand.
Yeah, but that's not what it says. I
I
understand
just
what
got to
you're trying to
preserve the
say.
record in case I've got to, you know, Rosedale Plaza was one of the cases I was involved in. Somehow the Court of Appeals agreed with me.
Yeah, but in this case.
Come luck there, I think.
I don't think that's going to happen in this case, but the licensee is the owner of the LLC. I do believe that this this MOU was in effect and is in effect, and his intention was.
I hate to interrupt you.
His intention was.
At the very
I
back
got
when
to
it says
finish my
entirety of the agreement is exactly where it says that, at the very end.
I've read.
It says the parties acknowledge this agreement is part and parcel of the support of the community for the acquisition of a BD7 at 309 Baltimore Street. It's a very, I knew I saw it there at the very end, page 5.
The
But okay,
intention,
I got,
the intention, your record is preserved. The intention of this MOU was for the licensee to be able to do certain things in the neighborhood, and that's why he signed it. That's why the organization signed it. That's why Mr. Panta signed this MOU. So it was in effect on these 3 days, especially the second and the third day. Mr. Fanta knew that he was not supposed to be selling these miniatures. He still was doing those on those dates. So I do find a violation of Rule 3.12, General Welfare, on June 11, 2024. I issue a $250 fine on that day. I do find a violation of Rule 3.12, General Welfare, on September 11, 2024, another $250 fine. And I also find a violation of 3.12, General Welfare, on September 13, 2024, a $250 fine on that date also. The cooperation, I do find a violation of 3.02A, cooperation. And on that one, I issue a $500 fine because he knew what was going on the whole time and kept doing it over and over and over again. So that's $250, $250, $250, and $500. 30 days of pay.
Okay. Done?
Yes.
Based on materials and testimony provided today, I also agree with the chair's findings, a violation of Rule 3.12, General Welfare, with a fine of $250. Violation of Rule 3.12, General Welfare, with September 11th, $250. And violation of Rule 3.12, General Welfare, September 13th, $250. And the violation of Rule 3.02, small a, with cooperation, with a fine of $500.
Based on the testimony heard here today, I find for a violation of Rule 3.12, General Welfare, the fine is $250. Violation of Rule 3.12, General Welfare, on September 11th. I find for a violation, that's $250. Also, a violation of Rule 1.12, General Welfare, for September 11th. I find for $250. In violation of Rule 3.02A, cooperation, I find for $300. This is on September 13th, 2024.
All right. Mr. Page.
Yes, Mr. Chairman, exhibits for the record. Violation report, number 1. Exhibit number 2, 6 photos. I'm sorry, exhibit number 2 through 6 photos. Exhibit number 7, violation report. Exhibit number 8, violation report. Exhibits 9 through 17 photos. Exhibit number 18, an email exchange from Wendy Moselle. Exhibit number 19, case law, Rosedale Plaza Limited Partnership. Exhibit number 20, a copy of the current liquor license for year 2020, effective 1/4/22 and ending 4/30/22. Exhibit number 21, a copy of the MOU.
And there is a legislative fix to fix this issue. So hopefully they can talk to you to be able to
Well,
move this to BD7.
I don't want to create an international issue, but, we'll get into it. I just, you're ready to make it go on.
Okay, all right. Thank you very much. All right, next.
Diorche Robinson, Club International LLC, trading as Club International, 2301 West Baltimore Street, Class BD7, beer, wine, and liquor license. Violation of Liquor Board Rule 3.12, General Welfare, on July 5th, 2024, operating the establishment with a generator. Please come forward.
Is it good afternoon?
Abraham Hurd on behalf of Club International LLC. To my right is Miss Robinson and her brother, well, I call him Windsor, but yeah, Windsor.
Is this going to be a mission?
This is going to be an admission. Okay. I could have had some fun, but it's been a long day.
We had a lot of fun today. Okay. So go ahead, Agent.
On July 5th, we were at the location with the Social Club Task Force, and the location was running with a generator. The fire department shut them down due to unsafe conditions, and on July 10th, Inspector Todd Hope followed up, and at that point, the housing department had also posted that they had to stop any type of work because it was unsafe wiring.
I would ask that the last part be stricken, simply because the violations from the 5th and the 10th is not an issue today.
That's fine.
If I may, in mitigation?
Yes, go ahead. You have any
Thank you.
question- no questions at all, though?
No, I mean, there was a generator. That seems to be the violation, so, yeah. Since that time, my client has worked with BG&E and various city agencies to get everything resolved. It's taken more time than anticipated, at significantly more cost than anticipated, and they're open and everything's fine now. No more generator, and that's all there is to it. This is their first violation, I think, in like 14 years. There were a couple of odd ones back before I was around, but there's been some membership change since then, so I think they've done pretty good. And again, since everything's been mitigated, we would ask that the violation be nominal or zero, if at all possible. They're a good operator. They're a part of the community. Again, I think the location has been there for, I want to say, decades at this point. It's always been a family business. Regardless of whatever punishment the board may dole out, they've spent thousands of dollars resolving any number of issues that have come up through various inspections since that date. And they're just trying to continue operating.
Okay. Any questions, Commissioner?
No questions.
Okay. Based on the violation report, the proffer made by counsel and any of the testimony given today, I do find a violation of 3.12, general welfare, but seeing that the issue has been rectified and no history of violations in the past, a nominal $150 fine and 30 days of pay.
Thank you.
Based on material and testimony provided today, I also agree with the chair's findings, a violation of Rule 3.12, general welfare, with a $150 fine.
Based on the testimony given here today, I do find for a violation of Rule 3.12, general welfare, on July the 5th, 2024, reference operating an establishment with a generator. That's bad. I do find, because of what was said, I do find $150.
Thank you.
All right, thank you so much.
You be excused?
You may be excused.
Exhibit-
Thank you, Mr. Page.
Exhibits for the record. Exhibit number 1, violation report. Exhibits 2 and 3, photos.
Mr. Hurdle.
Yes.
One quick break.
Thank you. Okay. We're going to take a thank you. So we're going to take a 5-minute recess.
Off the record, 12:56.
You guys ready?
I apologize.
Patricia.
Here we are back on the record at 1:02.
You're right.
All right, we're back on the record.
The October 10th proceeding of the Board of Liquor License Commissioners has resumed, and we're moving on to the next case. Sharon Jackson, Young Kim, Kai Suk Kim, Royal K&K Inc., trading as Royal Liquors, 1800 Division Street, Class A beer, wine, and liquor license, violation of Liquor Board Rule 4.20, specific requirements and prohibited activities by license type. On July 23rd, 2024, patrons were allowed to drink alcoholic beverages inside the licensed establishment. Please come forward.
All right, please raise your right hand.
Do you swear or affirm under penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth? I do.
Yeah, I do.
Okay. Are you going to admit that there was a violation? Or are you going to, is this an admission?
Yeah, I mean, we have, get with the explanation.
Okay.
And Mr. Chair, if you could identify yourself.
Domingo Kim, I'm representing Mr. Young Kim and Castle Kim. I have power of attorney from them, copy of them.
Okay, well, we're going to get to you in a little while, but you're saying this is an admission, you're going to explain why, what happened later on, okay?
Yes, sir.
We'll get to you in a second. Go ahead, Agent.
Agent Perez, Baltimore City Liquor Board. July 23rd, approximately 10:45 p.m., I responded to a complaint at the location for disturbing the peace. While I didn't observe any indication that this establishment operation was disturbing the peace, I observed two African-American males having a conversation inside the store. One of these gentlemen was drinking what appeared to be a Heineken beer. I observed this gentleman finish his drink and toss the bottle in a trash can that was inside the store. I made contact with the store clerk, Mr. Koo Suk Kim, and asked him why he was allowing on-site consumption of the store. Mr. Kim didn't understand what I was saying, possibly to a language barrier. I asked Mr. Kim to contact his manager, and he called Mr. Domingo Kim via telephone. He told me he was the manager and operator of the establishment. I advised him of the violation that I observed, and I also made him aware of the 311 complaint received. After issuing the violation, I dispatched the establishment without any further issues.
Okay. You have any questions for Agent?
Yes, when you called me over the phone, I asked you to hold the citation. You say you will hold the citation. You need to make sure that I put up the signs and those things.
That is correct. However, upon reviewing the violation, I submitted the report.
Yeah, say something.
Okay.
Now it's your turn. You guys can say whatever you want to say at this point.
On that day, I got a phone call from the inspector saying that we did the violation. So I asked the inspector to hold the citation. I will put up the signs and everything next day, and he said okay. And what I did was I put up more than about a dozen signs on the store, all over the store, making sure that people doesn't hang around the store and don't drink inside the store. We did what we promised with the inspector, and she's working at the store, and whenever they try to drink inside of the store, we ask his customers not to drink and do not hang around the store, and we try to keep our promise best we could.
Okay. You understand that our agents can't hold a violation. Once they see a violation, they have to violate you. Okay. Go ahead. You have anything else to say?
Okay, the day...
Please identify yourself. Say your name.
My name is Sharon Jackson.
Sharon Jackson.
I also work at this store on Thursdays and Fridays. Particular day, the agent came to the store and he gave me the paperwork to give to Mr. Kim. He was talking to me about what happened. What he stated to me, also with the inspector there, he stated to me that when he pulled up, it was two guys outside drinking and talking. And one of the guys came in, drank the last out the bottle and put it in the trash. I said, oh, so he wasn't really drinking in the store. Remember?
I do remember our conversation. You weren't present the day of the violation.
Not the day of the violation,
Okay,
but I'm going by what you told me.
Correct. This violation occurred on July 23rd. You got to understand that I visit
forgot.
all the establishment throughout the months, and I'm not going to remember specific facts 2 or 3 months after the violation. After I came to the office and I read the report and I refreshed my memory, I did realize I made a mistake on the facts I explained to you the time I visited the establishment to serve the hearing summons.
And Agent Perez, so after you observed what you observed, you wrote your report immediately, so?
Correct.
So that's the best record as to what happened
Yeah,
today?
my report was written just a few days after 7/23/24. I can refer, to have a date. Report was written July 28th, 2024, about 5 days later.
Okay.
We have
We haven't had any violation or citation for a long period of time.
Okay. Anything else? Okay. Well, thank you. And it seems like you guys made some efforts to make sure this doesn't happen again. Yeah, and I don't see any record of any violations or anything on your record. So for this, I do find that there was a violation of Rule 4.20, the specific requirements prohibiting activities by the license type, on July 23rd, 2024. I would only give a nominal fee of $150 and 30 days of pay because it's your first violation, and it seems like you guys have taken this very seriously to make sure this is not going to happen again in your organization, right?
Right.
Yes.
All right.
Yes, based on material and testimony provided today, I agree with the chair's findings. A violation of Rule 4.20, specific requirements, prohibited activities by license type with a $150 fine.
Based on the testimony given, I find for violation of Rule 4.20 on July the 23rd, 2024, reference allowing patrons who drink alcoholic beverages inside their licensed establishment. I also find for assess a $150 fine for that violation.
Okay, Mr. Page.
Exhibits for the record. Exhibit number 1, violation report. Exhibit number 2 and 3, photos. Exhibit number 4, service request summary. Exhibit number 5, photos of signage.
All right. Good luck to you guys.
Thank you.
Thank you, guys. All right. Ms. Jackson.
Olatunde Depolu, Good Budget LLC, trading as Club Bellissimo, 1001 through 1003 East Pratt Street. Class BD7, beer, wine, and liquor license. Violation of Liquor Board Rule 3.02A, cooperation on August 3rd, 2024, being belligerent with Inspector Brown and failing to sign inspection form. Violation of Liquor Board Rule 3.033, records on August 3rd, 2024, failing to provide employee records when requested to do so. Violation of Liquor Board Rule 3.031, records also on August 3rd, 2024, for failing to provide alcoholic beverage receipts. Please come forward.
Okay, it's just going to be admission.
No.
Raise your right hand.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good afternoon, Inspector Brown from Baltimore City Liquor Board. On 8/3/2024, I responded to this location for a 311 complaint for loud noise. Upon my arrival, no music was playing, so I introduced myself to the male employee that was there, and I told him about the complaint, and it was unfounded. So I also advised them that I will be conducting a routine inspection, and this will be their first inspection for the new year. The male employee advised the manager will be here in 10 minutes. While I was waiting, I asked the employee for a trader's license, alcohol awareness, and a recent invoice. The manager came into the establishment, and I asked him for the same credentials that I asked the male employee. The manager produced the invoice that was owed the month of May, and I advised him that I would need a more recent invoice. He advised he didn't have one. Then I asked for the invoice for the Don Julio, Ciroc, Hennessy, and Absolute, since it was unopened on the shelf. The manager phoned the owner via FaceTime and gave me the phone. While speaking to the owner FaceTime, he began to become very belligerent and loud, using curse words and stating, "You're the only one that come and write violations. You trying to stop a black business? I already don't make much, and you never give me a break." I immediately called Chief Chris Amalis, who spoke to the manager and advised him to cooperate, or a violation would be written. I then asked again for an updated invoice, and he said he don't have one. I asked for employee records. He said he didn't have none. I asked for his ID. He said he didn't have it. I asked him to sign my inspection sheet. He said he not signing nothing. So I advised him I would give him a violation, and I left.
Okay. You have any questions?
No, but I mean, it didn't really. Okay, things didn't really go down.
Can you say
the
your name
way-
first?
Oh, my name is Olatunde Depolu.
Okay.
So on that fateful day, when she walked in at 9:30, we were not open. The gentleman she met when she got there was just a cleaner. He just came in there to clean. So as soon as she walked in, I guess he left the door unlocked, but the open sign was clearly off. It wasn't on. So he called me immediately. I was out of town. I was even sick because I had an accident. So when the gentleman called me, I was on the phone and I asked to speak with her, explaining to her that the manager is not around yet because we're not open. So before the whole call, I was talking to my brother who happened to be in the neighborhood. So I texted him to please come around so he can help the guy out because he won't be able to, find anything. So when my brother got there, that was who she was referring to as the manager. That's just my brother. He don't work there. He's just my blood brother. So I was able to point him in just to cooperate. All right, so she started asking for all these things. I asked him to go where he can find those stuff. He was able to find a receipt, which happened to be the latest receipt that, that I have. So she said that was too old. So I explained to her that we've not had enough sales. I only buy when I'm out of stock. Whatever receipt that was given to her was the most current one that I had. Then she went ahead and asked for employee records, but he couldn't find it. Actually, before that, I told her, I said, I don't know when the manager will be there, but he will be there before 10 o'clock for sure. Does she want to wait? Or what does she want me to do at that point? Because she walked in at 9:30, we open at 10. So she said she was going to go ahead with the inspection anyway. So that was why when my brother came around, I tried to cooperate just to make sure everything go well. But he's not an employee in the building. He's just helping me out. So when that went on, she then asked for employee record. He couldn't. He don't have the keys. He can't get to it. So then she then said she was going to give me a violation. I said, violation for what? She said, there are bottles on the floor. I said, the cleaner is still working. He was the one who put it there per my instruction because I keep account of the empty bottles, especially when I'm not in town. I explained all that to her. Then I'm like, why is it that every time you come here, you always like to go for violations? You came here for a noise complaint. Obviously, the establishment was closed. Nobody was there. No music was playing. Fine, you wanted to do the inspection. We were not open. The manager that will assist you with getting you everything you need is not around. I explained everything to her, but she kept going and kept going. That was when I'm like, you don't have to give me any violation every time you come. It wasn't like I was, cussing her out or being belligerent. I was just stating the facts. Then, I don't know, nobody called me. My brother eventually did FaceTime. I was trying to show him around, show him everything that I could afford to, that he could help with. That was all that happened. And she walked out during at some point, and that was it.
See? So you said you weren't being belligerent?
I mean, it's kind of dicey because I don't know if she saw me. I was sick, like I had an accident. I was in California that day. I got stuck in there because I had an accident. But she kept going, and it was like after one thing, it's the next, it's the next. She just kept going. At some point, it got on my nerve a little bit. I'm not going to lie to you. I was a little bit loud, but I wasn't like out of control.
Do you know that your staff has a duty to know where the records are and to show those records when requested immediately?
So like I said, the only person that was in the building when she walked in was the cleaner. It wasn't a staff. It was just hired to do
I understand that.
Like a routine cleaning. So there was nobody else that could help her, that could present those documents.
But your testimony also stated that you had your brother go through and you were trying to direct him to where
Yeah, but he
things
didn't
are.
have the
He couldn't find
keys to, because I don't keep like employee records and stuff where anybody can just find it. I have it. She knows the other gentleman who is the manager, the tall, dark-skinned guy. He's the only one who have access to all those other stuff. Anybody that just walk in there can just go in there and pick up stuff. They don't know where, those things can be found. And if they know, they might not have a key to get to it.
Have you made any steps to make sure that?
Yes, I put everything that needs to, that she can ask for. I make sure it's reachable in case I'm not around.
Okay. Have you gone back to the location?
I have been back last weekend, but I didn't do an inspection.
You didn't do an inspection, no?
No.
Okay. And how long were you there, Inspector Brown?
I was there maybe 30 minutes.
And you got there at what time again? Around 9:30, is that what it says?
9:24.
So you were there to around 10
I'm
o'clock?
sorry. That's Tari's.
No, she wasn't there for 30 minutes. It was just like 15 minutes because I was on the phone the whole time.
I got there at 9:30.
Okay. And did the establishment open at any point when you were there?
No, he was beginning to open when I left out.
And did the manager come that he was?
It was a dark-skinned guy that came through the door. And that's the one that I gave the phone, and he spoke to Chief Chief.
Oh, okay. Because he didn't talk to me.
Okay.
Because he talked to him on the phone, and he advised him that he needs to cooperate with me. And he wasn't even trying to talk to me. He was mopping, walking around, just moving mops, going around to different rooms.
Okay. Any questions?
Yes, I have one.
No, I just want to make a statement that she's an agent, that's her job. And I, I'm just saying it really wasn't needed to be belligerent and curse at her.
I
You know what I mean?
didn't cuss her out at any point.
Were you belligerent? Were you belligerent?
My voice was just a little bit loud.
Yeah. What about her? Was she belligerent? No?
I won't say no, because I've had complaints from my employees, and I'm being honest. Right from like security, that is not her first time there, and that was why I made that statement. Every time she walked through, my employees have complained to me that she's always hostile. And she has been hostile to me at some point before. So that was why I said.
But this time she wasn't hostile.
Well, when she
She's a very
kept
calm
going,
person.
I already explained to her that I told her, do you mind waiting till my manager gets there so that he can help you out? Or how would you like to proceed? Because at that point, if my manager can't get there, then you can't get those things you're looking for, especially because we are not open.
Okay.
If we were open, then that would be my fault not to provide you those documents. But at that point, my manager resumed my assigned time. If he's not there, I can't really, blame him for not being there at that time. Okay. So I explained that to her, like, how would you like to move ahead? And one thing I was going to say before, the reason why the report was not signed was because she wrote in the report, because I told my brothers to read the report to me. She said no invoice was provided. And I said, that is wrong. We provided you an invoice. I'll be more comfortable to sign it if you put the information on that invoice, even though you are not accepting it as a good one. But the fact that you said we didn't provide you with no invoice, it's not true. I told her I would prove myself.
That's not true.
Oh, that was what I told my brother on the phone.
His brother never asked me for my report. I was trying to give it to him to sign.
Yeah, then he took it. I said,
One at a time,
He
please.
walked away from me
No.
and said, I'm not signing nothing.
He read the whole
Wait,
report.
let her finish. And then.
Okay.
I
Do
didn't
you have a
whole
copy of the report?
It's
Okay. So, well, I heard before. Do you have any questions?
Yes,
So we can move on.
just one easy one. How did she get inside the store
So the cleaner accidentally left the door.
accidentally?
Yeah, because I always tell them lock the door, especially when it's cleaners, because nobody's supposed to be there.
And did that invoice have any of the Don Julio, the Ciroc, the Hennessy, the Absolute?
That one didn't have.
I'm asking
No, I have not.
that wasn't on there?
No.
And you did see those items on the shelf?
Yes, and I've
On top
submitted
shelf.
photos as well.
Okay, all right. I have no other questions. You have any questions?
No questions.
No.
Any questions given what I stated? No?
Yeah, so she asked for a recent receipt, which was what I gave to her, which was the most recent we had at that time. We have stock from way back that I've not even sold that are still sitting on my shelf. If she asks for older receipts, she will see that we had those. But the receipt she had that was given to her was the most recent one.
Okay.
Yeah.
Which didn't have some of the items that
Yeah,
you had on the shelf.
I mean-
So this is what we want to hear, though. Like, even if a mistake was had, we want to hear that you've made steps
Yeah,
so
yeah,
this
yeah.
won't happen in the
Yeah.
future. So that's the most important thing here, given that your record, it's not, you don't have a bad record, you have one violation on here, but that's the kind of thing that we want to make sure that this is not going to happen again, and we want to make sure that you're also respectful to our agents and our inspectors that come through, because it
And
can be a dangerous job for them, and they're just trying to do their
I
job. You
get it.
understand
And
that?
she can attest to it. There has never been any form of threat whenever she come to my establishment. We've never been any way be rude. As a matter of fact, the only reason that would make me raise my voice that day was because of what I was going through. Because I drive trucks. I was all the way to California when my truck was involved in an accident. I was receiving treatment that night. I was even talking to my brother about the accident when the whole call came in.
Okay.
So, but when she kept going, after I tried to cooperate, maybe that was why my voice went up, you know.
Okay.
Yeah.
All right, so I find that there was a violation of Rule 3.02A, cooperation, on August 3rd, 2024, a violation of Rule 3.033, records, on August 3rd, 2024, and a violation of 3.031, records on that same day, August 3rd, 2024. Like I said, you stated that you've made some changes. The staff knows where the records are. This shouldn't happen in the future.
I have a question.
No. Let me.
Okay.
We need to finish doing our ruling, and then you can ask her a question. Your last violation was on 6/27/2024, this year, but it was a restroom violation. It wasn't a records violation. So I'll issue a $250 fine for the first violation of 3.02A, cooperation, a $250 fine for the 3.033 records violation, and a $250 fine for the 3.031 records violation, and I'll give you 30 days to pay. But like I said, since I feel like a lot was going on at that time, but you still have to be respectful. You understand that? Yeah.
Okay, yeah. In violation of Rule 3.02A, cooperation, I disagree with the chair's fine of $250, and I vote $500 fine on cooperation. In violation of Rule 3.03, records, $250 fine with the chair. Violation of Rule 3.031, records, I agree with the chair, $250.
Based on the testimony given here today, I find for a violation of Rule 3.02A, cooperation, on August the 3rd, 2024, being belligerent with Inspector Brown and failing to sign the inspection report. I find for $250, 30 days to pay for that violation. For violation of Rule 3.033, records, I find $250, 30 days to pay. I'm sorry, let me repeat that. Violation of Rule 3.033, I do fine for $250, but you see how close this stuff can be? If I go with him, you're gonna pay $300, you're gonna pay $500. You gotta respect her. She has a hard job to do. It may not seem hard to you because you're there, you're comfortable, but she has to go into establishment. Look, just work with her. But again, $250, 30 days to pay. Violation of Rule 3.031, records, $250, $30 to pay, 30 days to pay.
Yeah, and like my colleagues stated, this is a dicey issue, and I did go kind of low, especially with the cooperation, because that's a big issue, you know?
And I apologize. I mean, I'm not that type of person. I'm usually cool. Everybody who know me know I'm usually cool. I apologize, you know, if I raise my voice.
Yeah, I appreciate it.
Thank you.
Thank you. Okay. Mr. Page?
And I have a question. I just want to be clear on that part. Like, when we're not open in such cases, because there are times when people just come in there to work, you know, they might accidentally leave the front door open, as the gentleman did. They don't know anything about the establishment. What am I, you know, supposed to do at that point?
You can have those conversations after the fact, and,
Okay.
and they'll give you some good guidance on what you do and how the door should be closed or open at the time. And
Okay.
Okay? All right, Mr. Page.
Exhibits for the record, Mr. Chairman. Exhibit number 1, summary report.
All right, thank you very much. Good luck with you.
Thank you. I appreciate your apology.
Right? You're welcome.
I think we're on our last item.
Yes, sir. Final case for the day. Terrence Dixon, New Terra Cafe LLC, trading as New Terra Cafe, 101 East 25th Street. Pardon me, Class B, beer, wine, and liquor license. Violation of Liquor Board Rule 4.14, live entertainment without authorization on April 30th, 2024, for engaging in live entertainment after the hours that were approved by BMZA. Violation of Liquor Board Rule 3.062, signs and hours of operation on April 30th, 2024, failing to present his liquor license when the inspector requested to see it. And finally, violation of Liquor Board Rule 3.02, cooperation on April 30th, 2024, April 30th, 2024, for failure to sign the inspector's report to acknowledge receipt. Please come forward.
Mr. Dixon, could you please raise your right hand?
Do you swear or affirm under penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
And would you be Mr. Dixon? Are you Mr. Dixon?
Yes, my name is Terrence Dixon, owner of the Terra Cafe.
And Mr. Dixon, are you going to make an admission to this, or is it going to be a full-out hearing? You can make an admission and then say your explanation of what happened, or you can have a hearing and deny the allegations. Which one would you like to do today?
I'd like to say what I remember of happening.
Okay.
Is I can't afford counsel. Still trying to survive from COVID. All right, we're trying to stay open best we can. And one of the things is that.
So what we'll do is we'll let the inspector go ahead
Okay.
and speak, and then I'll let you say whatever you have to say, okay?
Yes, sir.
Yes, all right. Go ahead.
On April 30th, I responded to the location in response to a 311 complaint stating loud music every Tuesday night. I parked about a block away, and I made my rounds around the location, walked behind the location in an alleyway on the side, and I could hear the music was loud. Then I approached at 10:15 and spoke to Mr. Dixon. He immediately he was upset that I was there, asked me if I had a decibel reader, asked who complained. He said that he was being harassed. I walked to the rear of the location or the side. There was a band set up, a full band, microphone included. I noticed the back door was open, and when I walked up, the front door was also open. After that, Mr. Dixon called. He said he was calling his lawyer, again, because he was feeling harassed. When he completed his phone call, I asked for his license. He didn't want to provide that to me. I wanted to see what other restrictions were on there. He refused to provide that to me. I informed him that I was giving him a violation. He refused to sign that violation. And also, he walked away, and I spoke to his employee, and he had already directed him not to sign the violation. Then when I got to the office, I reviewed the restrictions on the license, and he is only permitted to have live entertainment Fridays and Saturdays, only up to 11 p.m. This was a Tuesday night. And that's it. I left, but as I left because he was getting very agitated. He refused to sign. He refused to provide me his liquor license, and I felt that it was time to go because I really wasn't getting much done.
You just said on Fridays and Saturdays, but on Sundays and Thursdays, the live entertainment has to stop by at 9 p.m.? Is
Yes.
that what you're trying to say?
Yes,
Okay,
per
and this
the
was on a
BMC.
Tuesday, and it was at 10:15?
Yes.
Okay. Do you have any questions for her?
Is this Inspector Jordan?
Yes.
Okay, all right. I don't have any questions right now, but maybe in a second I will, I'm not sure. One of the things is this, is that this MOU apparently goes all the way back to 2011, okay? From COVID and before then, we've been doing the different entertainments, poetry. We might do a speaking or something of that nature. So it never dawned on me that we couldn't go past 9. They have been out several times. And the call has always been for loud music. I took it upon myself that back in 2011, we had the health department come out with a decibel meter, and the gentleman from the state that did the decibel meter, he gave me instructions of how to monitor to make sure that I'm in compliance. He decided on 3 spaces. One was at the corner of 25th and St. Paul. The next one was at the alley right there in front of the Charles Village Benefit District. The third one he suggests is always go in the back of the building. I purchased a decibel meter. I do a sound check with anybody that's doing anything there. If you're coming to speak and sell your book, I'm going to sound check if I think it's going to be loud, all right? Whenever they come, I ask them, all right? Police used to come and they stopped because of the decibel meter. It was in compliance. I asked them, listen, I have a decibel meter. Can you help me? I want to gauge right. It's not like I'm trying to do wrong. I have been on that corner for over 25 years. The business has been around for 15 years, 10 months, 10 days, and probably about 12 or 13 hours right now, okay? So I constantly know that I keep in compliance with everything, okay? And when she told me last week, and I took it upon, and I looked up that it was that time, this week I canceled it, all right? See, I don't try to get problem, I'm asking for help. I'm asking for how do we make this work for business in Baltimore right now for myself to keep us open, employed, and the sharing of a decibel meter and sharing with me that, listen, I am gauging it right. The rate is at 58 decibels, and normally where I put it in about 52 or 54 because of that wu-ta with the drum or something if someone hits a high note. A little bit before 11 o'clock because that's the guidelines that I was under the impression that I could do. All right. I stopped that 5 minutes before. Matter of fact, there was a band that no longer played at my cafe because they couldn't be in compliance with me and stopping it like that. They might go over 5 minutes or 4 minutes and they're in the move. No, it's 11 o'clock and that's it. So, and when Inspector Jordan shared that she actually went to the back and she saw the band and she saw the back door, my liquor license is right there. They've been to my place several times. It's posted, it's there. I've never denied them any of the liquor license or anything of that nature because on my liquor license, it does state that I have, that's my one little shield. It states that I can do live entertainment, all right?
So did you not give the liquor license when it was requested? Did you not show it?
I've never done that, so I don't understand how it says that there. If I've given you my liquor license for the last 20 times, why would it be one time that I would not give it to you, all right? I understand I have to respect the inspectors, and that's just not from the liquor board. I originally did my thing in Baltimore with construction, all right, with rehabs and stuff, so I know the importance of the inspectors. They're the ones that you can grow or they can shut you down. So you give them carte blanche at all point in times. Even if I don't agree, I'm going to give you everything that you want. But I just look for equitable protection, that I have the same rules of everybody else. See, there are other businesses in my community that they do these things and they don't get as many calls as I do. I get a call every Tuesday, no matter if I adjust my decibel meter, all right, and I do my stuff, and I offered it to them. Whenever I offered to the office, I said, please help me. Let me, listen to this decibel and see. Because what you hear and I hear and somebody else hears is going to be completely different. But they always refuse to take the decibel meter and just listen. You know what I mean? I look at that inspectors are not here to close me. They're supposed to be here to help me and help me grow. So when I get into an energy that they have a consistent of just wanting to write me up and not work with me and not help me figure out a plan that I can be righteous, it's a disconnect there. So that was one of the things. But then also, like when I spoke to call 311 and I asked them, because if you ask me to turn it down and when they come and they say close the door, I close the door. When they say turn it down, I turn it down, okay? But if you call 311, and this is the reason I was referring to harassment, when you call 311 or 911 and you say a noise complaint, they're gonna send the police first. I just found out recently that if you say something that is a violation with the liquor board and some other magic word, what'll happen is they'll automatically revert to the inspectors, okay? So whenever they come, police have come before, I've shut the door, or I've turned the music down, or they gave me the thumbs up and say, "You're all right, Mr. Dixon?" I'm not new there. I've been there for over 25 years. I've been nothing but an asset to the city and to my community, and that's what I do it for. Right now, we're still trying to get through COVID. You know what I mean? I had 20 people employed. Now I'm down to like 6. I used to be open 7 days a week. Now I'm open 3 or 4. Okay? So I would never jeopardize the liquor license or do anything that's going to be crazy, because guess what? I end up here. All right? I'm a smart cat. All right? I end up here. So if I do the right things out there, guess what? I don't end up here. All right? So when I got this and I read it, I was very surprised because I've never denied that.
So you didn't deny
Like I
that.
said,
So
that's one of
Can
my
we ask
shields.
Inspector Jordan? Let's ask Inspector Jordan.
He did deny his liquor license when I asked. He was not cooperating that night at all, so much that I left because I felt like it was just escalating.
Have you been back to the location after this?
I have for the same exact complaint. And if I could introduce, this is the advertisement that lists that he has live entertainment every Tuesday. And this is for every occasion that, some of them that he's had it on.
Oh, that's fine. Okay.
And if I could add something
But it doesn't
else.
say that he can't have it, it's just he has to stop by,
On
has to stop by a certain time.
He can't have it on Tuesdays. He can only have it Saturday and Sunday, I believe, Friday and Saturday.
No- So no portion of the property shall be used as a restaurant with live entertainment after 9 PM, Sunday through Thursday. Okay. What's your understanding? What's your understanding of when you can have live entertainment?
Well, you want to know it now? I realize that that's why I canceled it this Tuesday. All right? All before, they came many times. Not once did they ever say, "Hey, you're out of order. You can't have it at 9 o'clock. You can't have it past 9 o'clock." Never. And this is the first time that it has actually come around in that and brought it to my attention. Got a lot on my mind. Not getting too old, but got a lot on
And
my
as
mind.
one more question, you have a violation in 2021. Looks like it's the same type of violation.
For what day?
August 12th, 2021, live entertainment without authorization. But I just wanted to make sure, it sounds like you know what the rules are, you know what you can and can't do.
I mean, I've had it since 2011, and I understand, like I said, and you learn real quick when you're doing construction about inspectors. You learn the power that they have, okay? So that lesson that I learned there, I bring it into every day here.
Okay.
Okay? And like I said, is that just like when she says close the doors or whatever, and
So, I'm ready. Any questions, Commissioner?
No.
No.
No questions? No questions? All right. So as to Rule 4.14, I do find a violation of the live entertainment without authorization. I'll issue a $200 fine on that one. I feel like you are completely aware now of what can and can't be doing, the hours operation.
now I know, yeah.
Yeah.
I did, listen, I was going by what basically, when you read Baltimore City and you look it up, it's 58 decibels up to 11 o'clock, and that's what I use as the gauge for the whole thing with the live entertainment, all right? And if I'd known that I couldn't go past 9 o'clock, guess what? I definitely wouldn't have done it, okay? And I've been actively, we tried again with zoning last year to expand that perimeter, to expand that to where we could actually do live entertainment outside, because during COVID, we would have jazz outside in the garden, and the great part about this entertainment is that it really facilitates the business. that they come out, you get people to come out
We
and they
want you
come
to be
back.
successful. We want you to be successful there, but, you know, you have to follow the rules and regulations. I think that you're going to follow them and know you know them now. So I do find a violation of Rule 4.14, the live entertainment without authorization, engaging in live entertainment after hours that were approved by BMZA. I find a violation of Rule 3.062, the signs and hours of operation, failure to present the liquor license when it was requested by the inspector, and a violation of 3.02, cooperation, the failure to sign the inspector's report to acknowledge. $200 fine for each of those as a minimum, as a nominal fee, because of what you said today, that you do know the hours of operation, and you did close down, this Tuesday? And this coming up Tuesday, are you going to be open again next Tuesday?
No, right now what I've done with Mike is that, and I've told him that right now we're at a pause. I can't.
Okay.
You know, but it's not just about me, it's about my employees, it's about my community, you know, so to get crazy and be all with bravado, no.
Okay, so $200 for each of those.
$20 for each of those?
$200 for each of those. No, that's a low fine.
Like I said, I'm still battling. Do I have a little bit of time to pay these things?
Yes, 30 days of pay, to pay the whole $600. Is that not enough time for you to pay?
We're not even open now.
Okay, 60 days to pay.
Thank you.
All right, 60 days of pay.
Okay. Based on material and testimony provided today, I disagree with the chair. No, going backwards. I agree with the chair's findings of violation of Rule 4.14, live entertainment with authorization of $200. Violation of Rule 3.62, signs and hours of operation with $200. I do disagree with the chair on violation of Rule 3.02, cooperation, and a fine of $500.
You guys always make me the bad guy. Based on the testimony given here today, I find for a violation of Rule 4.14, live entertainment without authorization. On April the 30th, 2024, reference engaging in live entertainment after the hours that were approved by BMZA. For violating that rule, I find $200, 60 days to pay. Violation of Rule 3.062, signs and hours of operation. On April the 30th, 2024, reference failing to present his liquor license when the inspector requested to, $200 fine, 60 days to pay. Violation of Rule 3.02, cooperation. A licensee and its employees should cooperate with the state or local agencies in the course of conducting official business. On April the 30th, 2024, reference failure to sign the inspector's report to acknowledge receipt. $200 fine, 60 days to pay.
So as you can hear, the cooperation ends up being an issue when the liquor board feels like you're not cooperating with our inspectors and agents. But I think we're going to get over that. So thank you and good luck to you in the future, okay?
I got a question for you. Is that like, I got a check for you, and a check for you, total?
No,
I
we
mean,
don't.
No, we don't.
Exhibits for,
No,
Go ahead.
okay, 725 total? Okay, I'm thinking, boom, boom.
No.
1 second, please. Exhibits for the record, please.
We're off the record at 148.
Exhibits for the record. Thank you. Exhibit number 1, violation report. Exhibit number 2, zoning appeal. Exhibit number 3, service request. Exhibit number 4, advertisement for live entertainment at the location. Thank you.
Thank everyone for being patient.
And And Mr. Chair, it has been a long day, but there being no further business before this board, the board is in recess until Thursday, October 24th, 2024 at 10:30 a.m. We're adjourned.